the Chief Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the Court is now in session.
The Clerk of Court will please call the matter at hand.
GR number 221697, Mary Grace Natividad S. Poe-Llamanzares versus Commission on Elections and Estrella C. Elamparo, and GR numbers 221698 to 700, Mary Grace Natividad S. Poe-Llamanzares versus Commission on Elections, Francisco S. Tatad, Antonio P. Contreras, and Amado D. Valdez. Appearing as counsel for petitioner are Attorney Alexander J. Poblador, Attorney Dino Vivencio A. Tamayo, Attorney Justine Christopher C. Mendoza, Attorney Sandra May T. Magalang, and Attorney George Erwin M. Garcia. Appearing as counsel for public respondent Comelec are Commissioner Arthur D. Lim and Commissioner Maria Rowena and Amelia V. Guanzon. For private respondent in GR number 221697, Attorney Estrella C. Elamparo. Counsel for private respondent, Francisco S. Tatad in GR numbers 221698 to 700, Attorney Manuelito R. Luna. For private respondent, Dr. Antonio P. Contreras, we have Dr. Antonio P. Contreras himself. As counsel for private respondent, Amado D. Valdez in GR numbers 221698 to 700, Attorney Amado D. Valdez, Attorney Melquiades Marcos N. Valdez II, Attorney Donna S. Agoncillo, Attorney Mark Andrew M. Santiago, and Attorney Lorenza Angelo G. Junicio. From the Office of the Solicitor General, we have Solicitor General Florinti Hilbay as Tribune of the People.
Thank you, Attorney Anama. May I request the rest of the council to please take their seats while Commissioner Lim will continue answering, and we will be proceeding with the interpellations with Justice Bernabe's questions.
Good afternoon, Madam Chief Justice and Your Honors. Good afternoon.
Okay. Thank you, Chief. Counsel, I am here.
Good afternoon, Justice.
Good afternoon. As previously discussed, there are 3 requirements to establish a new domicile of choice, and they are the physical presence in the locality, the animus manendi or intention to remain in the place, and the animus non revertendi or the intention to abandon the old domicile.
Yes, Your Honor.
Now, my question is, can these requirements, more particularly the animus manendi and animus non revertendi, be complied with by an alien who has not secured a permanent resident visa?
No, Your Honor, please. Such requirements, animus manendi and animus non revertendi, would be incompatible with the non-securing of a permanent resident visa. It would be consistent if there is a waiver of non-resident status.
So you are saying that this is a condition sine qua non to a establishment of domicile?
That is the submission of the Commission, Your Honor.
Okay. Now, how do you reconcile your position on this with the subsisting jurisprudence in election law that identifies only the 3 requirements for establishing domicile?
I'm sorry, I did not get the question, Your Honor.
Well, under settled jurisprudence, there are only 3 requirements, the ones that I earlier mentioned. How do you reconcile putting an additional requirement, which is the acquiring the status of a permanent resident as a condition sine qua non to establishing domicile.
Yes, Your Honor. Apart from the fact that it has been laid down by jurisprudence, and jurisprudence consisting of the decisions of the Supreme Court form part of the law of the land under Article 8 of the Civil Code, reason also dictates, Your Honor, that in the case of Filipinos, for instance, who have lost their Philippine citizenship by naturalization in a foreign country, automatically also lost their Philippine domicile. And when they decide to come back to the country, repatriate, avail themselves of the benefits of RA 9225, it does not suffice that they be here on mere physical presence, because that can be achieved by means of a visa-free balikbayan privilege of coming here. It must be coupled not only by, it must be evidenced not only by bodily presence, but also animus manendi and animus non revertendi. Now, all these requirements, Your Honor, would be of note if such animus manendi and animus non revertendi do not become manifest and conclusive via waiver of non-resident status. It is only when the non-resident status is waived by securing, for instance, an ICR, that the intent to return and the intent to remain and the intent no longer to return to the old domicile become very manifest.
Okay.
I'm sorry for the long answer, Your Honor, but that is my impression.
Had Senator Poe obtained a permanent resident visa?
Unfortunately, no, Your Honor.
No, I'm not through yet.
I'm sorry.
Had Senator Poe obtained a permanent resident visa, thereby acquiring the status of a permanent resident, would you have ruled differently and reckoned her establishment of domicile from the time of his acquisition or application of a permanent resident visa?
Not at that point, Your Honor, please, because she would still have to establish animus non revertendi, considering that she remained a U.S. citizen and remained a U.S. resident all that time, as evidenced by her stay in the country, which was but temporary under a visa-free balikbayan privilege. Such obtaining of a permanent visa would not suffice in the view of the Commission. There must still be proof of animus non revertendi, Your Honor.
Now, if it is coupled with the overt acts that Senator Poe had submitted before you, would you have ruled differently?
Your Honor, please, the evidence submitted before us presented 4 different dates of acquisition of residence. And this we fully considered in arriving at the conclusion that she, in fact, has not re-established Philippine domicile prior to her affirmative and positive act of repatriation on July 18, 2006, coupled with bodily presence. I refer to the following dates, Your Honor. In her pleadings, sworn pleadings, she claims re-establishment of Philippine domicile on May 24, 2005. That's the first. The second is her COC for Senator, filed October 2012 for the May 13, 2013 elections, where she answered sworn entry 6 years and 6 months before May 13. That gives us November 2006 as point of establishment of residence. And then she demonstrated by saying that was a misimpression because the 6 years and 6 months was up to the date of filing of COC in October of 2012. Assuming that to be true, that would give us April 2006 as the date of reestablishment of domicile. And then here comes her 2015 COC for the 2016 presidential elections, 10 years and 11 months up to the day before May 9, 2016. That would bring us to June 2005. So which is which? May 24, 2005, June 2005, April 2006, or November 2006. The Commission fully considered this in our deliberations, and we could not help but make the observation and conclusion that she was indeed just testing the waters. Her Balikbayan free visa was good for 1 year. She allowed it to lapse in May of 2006, and barely a few days later, she opted now to file an affidavit of repatriation on July 8, 2006, and her repatriation was granted by BID on July 18, 2006. She was indeed very ambivalent. So, Your Honor, please, just to explain and answer the question now direct to the point, there was at this time, all of this period of time, no animus non revertendi, coupled with the fact, if I may hasten to add, that the husband remained in the U.S., never gave up his U.S. citizenship, never gave up his U.S. employment till after the later part of 2006, when the petitioner had already decided to repatriate. So that is the position of the Commission, Your Honor.
Okay, Counsel, let's go to another issue on the issue of jurisdiction. Now, based on the 1987 Constitution, the Comelec has the power to enforce and administer all laws and regulations relative to the conduct of elections. And also, it has general jurisdiction to decide, except the right to vote, on all matters affecting elections. That is correct, right?
Yes, Your
Now,
Honor.
under this authority, do you think that the Comelec is empowered to rule on the qualifications of a presidential candidate, irrespective of the good faith or bad faith of a candidate in making her declarations in the certificate of candidacy?
Yes, Your Honor, please. On the power to so rule and determine material misrepresentation, Section 78 of the OEC, which uses the phrase any candidate or any person for public office. It does not limit the focus of inquiry to local candidates only. A complaint or petition to cancel COC may be filed by any person on the exclusive ground of material representation that is false. And it refers to the filing of a COC by any candidate. The word any there includes national officials. Now, the second part of the question, Your Honor, as to whether the Comelec could so make a ruling, that is very well settled in jurisprudence, Your Honor.
Now, on a final question, assuming that your office found that Senator Poe was in good faith in making her representations in her COC, would you have nonetheless canceled her COC on the ground that she has not met the qualifications of residency and citizenship, not based on Section 78 of the Omnibus Election Code, but on your general power to enforce and administer all laws relative to the conduct of elections, as well as your power to decide all questions affecting elections under the Constitution?
Yes, Your Honor, with your kind indulgence, may I answer the question in what I would think would be an orderly fashion. Let me define first good faith, which is the premise of Your Honor's question. Good faith is an intangible or abstract quality that is not susceptible of precise statutory definition, but it implies honesty of intentions and freedom from knowledge of circumstances which would put the person upon inquiry. This is the definition of good faith in the case of heirs of Joaquin Liminse versus Viuda de Ramos. Now, Your Honor, applying this standard and definition of the Supreme Court to the case of the petitioner, she would have been put, as indeed she was put, on inquiry as to the following circumstances. The fact that, with all due respect to her, she is just an adopted child. She is not a natural-born citizen because the Constitution is very clear. She admitted she is a foundling, and she is a legislator, and the principle of ignorantia legis neminim excusat should apply with more force upon the petitioner. Despite all this, Your Honor, the Commission found it quite unfortunate that there was this submission in the BID representing that she was born not to adoptive parents but to biological parents, the Poe-spouses. And in the acquisition of property in San Juan and in Corinthian Garden, the deeds of sale recited, although the deeds of sale, the documents recited, Your Honor, that and the titles, rather, which were presented in evidence, recited on their face that they're Filipino citizens. A representation that was necessary to qualify her to acquire land, considering that she was then still an alien. So, it was somewhat an impossibility. During our deliberations, particularly in the second division Ilamparo case, we thought of good faith. We thought that this may be difficult questions that an ordinary person would find quite not easy to resolve. But the totality of the circumstances, the totality of the evidence, as mandated by Sabili, penned by the Honorable Chief Justice, commanded us to consider all this totality of evidence, and we thereby arrive at the conclusion, Your Honor, that she could not invoke good faith. And since good faith was an impossible finding, we would not have not found her ineligible because of the existence of good faith. It was simply impossible to find that there was good faith on her part. Now, to answer the question more directly, Your Honor, Section 78, in the view of the Commission, is plain and couched in simple language. It does not admit of good faith as a defense, in our view, Your Honor.
Okay, that would be all, Counsel. Thank you.
Thank you, Your Honor.
Justice Ardeleza.
Good afternoon, Justice.
Good afternoon. Good afternoon, Commissioner Lim.
Good afternoon, Justice.
I will limit my questions only to the issue of foundling. And my first question will be about what kind of findings of fact did the Comelec make with respect to foundlings. But before I go to that question, I will just recite to you, and if you need to refer to the pleadings, just tell me, because I will give you a chance to ask one of your many associates to give the pleading to you. Otherwise, I will recite the statements, including the page, and then I will ask my question. Will that be all right?
That will be all right. That will be all right, Your Honor.
Now, on the second division, this is the Elamparo petition. The allegations of the petition at paragraph 49 is that petitioner Poe, quote, being an admitted foundling cannot be considered a natural-born citizen, and of quote, because, and again I quote, the enumeration of citizen classified as natural-born is exclusive.
Yes, Your Honor,
Yes.
that is correct.
In paragraph 111, quote, the foundling bears the burden of having to prove by any acceptable means that he or she is a Filipino citizen. Do you remember that?
Just for clarification, with your kind indulgence, Your Honor is reading from our assailed resolution, Your Honor.
No, Counsel. I am still on the petition of Petitioner Elamparo.
Yes, Your Honor. Yes, Your Honor.
Again, paragraph 111 of her petition. It says the foundling bears the burden of proof. No, the foundling bears the burden of having to prove by any acceptable means that he or she is a Filipino citizen.
There is such allegation, Your Honor.
Yes. Now, I go now to the decision of the second division. The second division decision.
Yes, Your Honor.
On page 23, the second full paragraph of the decision of the second division. And I quote, "The fact that respondent is admittedly a foundling negates, at least at this time, any possible finding that respondent was born of a Filipino father." End of quote. Do you remember that from the second division's decision?
That is correct. We stand by that, Your Honor.
And then the en bank's decision, still on the Elamparo petition at page 31 is, and I quote, the Constitution is clear, the enumeration is exclusive verba legis.
That is correct, Your Honor.
Now, I go to the consolidated petitions of petitioners Tatad, Contreras, and Valdez. Now, the ruling of the first division, respondent, meaning petitioner Senator Pope, and I quote, could not definitively show her direct blood relationship with a Filipino parent since her biological parents are unknown, at page 25.
That is correct, Your Honor.
And it continues, quote, the probability that she might be born of a Filipino parent is not sufficient to prove her case, end of quote.
That is correct also, Your Honor. That is in the decision.
Yes. Now, I go now to the en banc decision of the Comelec. At page 17, quote, to reiterate, natural-born citizenship is founded on principles of jus sanguinis. Respondent is a foundling. Her parentage is unknown. Thus, there is no basis to hold that respondent has a blood relationship with a Filipino parent. This commission, therefore, cannot rule or presume that the respondent possesses blood relationship with a Filipino citizen when it is certain that such relationship is indemonstrable, end of quote.
There is such a statement, Your Honor.
And I stress, that's at page 17, the words the en banc used, we cannot rule or presume when it is certain, the en banc used that word, when it is certain that such a relationship, meaning a blood relationship, is, the word you use is indemonstrable. Do you remember that?
Well, if that is in the decision, Your Honor, we stand by it.
And then, also on page 17 of the bank's decision, on the first division, on the consolidated petitions, you also have these statements. Even if we concede that respondent is entitled to the presumption of natural-born citizenship, the fact that respondent is shown to be a foundling already shifts the burden of evidence in her court.
Yeah, there is such a statement.
Do you remember that? Now, this is my question. If as you say, and the en banc said, it is certain that direct blood relationship of a foundling cannot be definitively, that's your words, shown, or cannot be with certainty shown, because such blood relation is, in your words, indemonstrable. Then my question is, no amount of proof will suffice?
There is an amount of proof that can suffice. DNA evidence, Your Honor, as suggested by Justice Carpio in his dissent in the Set case. The Commission, in those sentences that Your Honor has read before the court, wanted to convey, although the sentences speak for themselves, but the ruling that was being conveyed, the ratio of the decision was that the petitioner admitted to being a foundling. Automatically, we must apply the definition and concept of what a foundling is. A foundling is a child of unknown biological parents. Correlating that once again, or also to jus sanguinis under Section 2, Article 4, under Section 1, Article 4 of our present Constitution, the same with the other constitutions, she cannot be considered natural born.
Thank you,
Now,
Counsel.
Yes, thank you, Your Honor.
Just to clarify, you referred to the opinion of Justice Carpio in the Set case, right?
Yes, Your Honor.
You refer to it now. You just referred to it, right?
By way of explaining the side of the Commission.
I have no question yet.
Yeah.
But your en banc decision did not cite that opinion of the justice, right?
I don't believe so, Your Honor.
It does not.
It does not.
And I am not sure now in which decision of the bank, when I say bank, of the Comelec en banc, which said we are not bound by the Set decision.
That is
I
correct.
think in one or both of them, there was a statement. Do you remember that?
Yes, Your Honor, by way of justifying our issuing a resolution notwithstanding the Set decision.
But now, you are saying that you are not bound, but you are invoking a dissenting opinion in the Set decision.
Now, we are just citing it to answer your question, Your Honor, that the foundling status of the petitioner is not something that is fixed or forever permanent.
Therefore, your position is that there is only one type of evidence that a foundling may present, and that is DNA evidence.
Although this was not discussed in the assailed resolution, the evidence that should have been presented, I express the view, not necessarily that of the Commission, in response to the questioning of the Honorable Chief Justice, that possibly secondary evidence might be presented in the form of other testimonies of people who might have seen the mother leaving the child in church, or family photos, baptismal records. We do not like to prejudge it now, but the totality of the evidence, who knows? It might satisfy the threshold of substantial evidence, but we are non-committal on this since we did not discuss the type of evidence that was needed to rebut the conclusion that a foundling is not a natural-born Filipino citizen, because our mandate, Your Honor, if I may elucidate on it, is under Section 78 of the Omnibus Election Code in relation to Section 2, Subsection 1 of Article 9-C of the Constitution,
Now,
which is
Counsel.
merely to find material misrepresentation, Your Honor.
Now, help me out here.
Yes,
When
sir.
you say non-committal, are you talking of yourself or are you talking of the full commission? Who is not committing to the position that only DNA is admissible evidence?
We have not deliberated on that in our assailed resolutions.
That is why I cannot find in any of the Comelec and Bank decision any discussion on type of evidence, right?
It was not necessary, Your Honor. It was needless to go into that or pointless to go into that because our mandate, as this representation tried to explain earlier, was merely to find whether or not there was material misrepresentation in the declaration that she was a natural-born Filipino citizen. And when the petitioner admitted that she is a foundling, the conclusion became inevitable that she is not natural-born, applying the strict and plain language of the Constitution.
Now, Counsel, you introduced another term, it is pointless. Now, again, I go back to the question. When you say it is pointless, then you don't even talk about burden of proof, right?
There was burden of proof.
No, I mean, you keep repeating who has the burden of proof. Your position is it is the petitioner Poe, right?
No, Your Honor, that was not in my opening statement, with all due respect. In this representation's opening statement, I made it very clear, Your Honor, that the private respondents, as complainants, so to speak, have the burden of proof. But that burden shifted to the respondent, or to the petitioner rather, to show that by her admission of being a foundling, she is a natural-born Filipino citizen. The burden of proof does not
let
shift.
me again just clarify. The statement that I'm still and I will only be on the foundling issue.
Yes, Your Honor.
Your statement that the various respondents, the petitioners in the Comelec, respondents in this court, they bore the burden of evidence, is your personal opinion or the position of the Comelec?
The position of the Comelec, that is in our resolution. Not burden of evidence, Your Honor, please. Burden of proof.
Now, you say now the burden of the evidence shifted to petitioner Poe, right?
When she admitted that she was a foundling.
So I still have the same question. When the burden of evidence shifted to her, is the only type of evidence admissible DNA evidence?
Not necessarily, Your
Not
Honor.
necessarily.
It would depend on the evidence that would be presented, and we will cross the bridge when we see the evidence, consider them in their totality, and determine whether it satisfies the requirement of substantial evidence, Your Honor.
In other words, you are not staking the position that the fact that a person is a foundling, it is conclusively presumed that he or she is not natural born or is conclusively presumed to be an alien. You're not saying that?
That is correct, Your Honor, because the status of a foundling could be shown otherwise, meaning, Your Honor, that the biological parent, for all we know, might be revealed by DNA evidence. And when we mention this, it is proper DNA evidence, like DNA presented in a judicial proceeding with all the measures put in place to assure the integrity of the result, Your Honor.
Now, I have another question. The petitioner, in this case, petitioner Poe, she is not asserting a claim that a foundling is conclusively presumed natural born. She is not.
I am not too sure, Your Honor, if she used or did not use the word conclusively, but her verified answer contains the affirmative defense, which incidentally it was her duty to also prove, that as a foundling, she is presumed under international law to be a natural-born Filipino citizen. I cannot just state offhand whether the word conclusively was used in that submission, Your Honor.
When you go to your memo, may I ask you to cover that? But so far, what I have read, I believe Petitioner Poe is not asserting that a foundling is conclusively presumed. Her claim is a foundling is disputably presumed to be natural born, citing some provisions in the rules of court and, of course, the international conventions.
With your kind indulgence, Your Honor, whether disputably or conclusively, a foundling is definitely not natural born and therefore does not qualify under Section 2 of Article 7, qualification for President.
I will go into that, counsel, now. Can the Congress of the Philippines pass a law to the stating that foundlings are conclusively presumed to be natural born?
I don't believe so, Your Honor, please, because that will contravene the Constitution. It will be repugnant to the fundamental law.
Now, I'll give you a second hypothetical. Suppose the Congress of the Philippines passes a law that says a foundling is disputably presumed to be natural born, constitutional or not?
No, Your Honor.
Still no.
Still no, because we go by the plain language rule. A foundling can never be a natural-born Filipino citizen because there is already existing legislation under the Domestic Adoption Act of 2003 that a child can only be considered a foundling after undergoing an administrative process, verification, hearing, summary investigation, conclusion that the child is an abandoned child with no unknown parent, and therefore a foundling certificate at that point only will be issued. So immediately we see, Your Honor, that an act is required to be performed to perfect or acquire a foundling's citizenship, let alone natural born. I mean, it cannot be natural born.
That's fine, counsel.
Yes, Your
I'll
Honor.
go now to my next question. At the last oral arguments, I seem to have remembered that you repeatedly said that the recourse of a foundling is through remedial legislation. Do you remember stating that?
That is correct, Your
Now,
Honor.
what do you mean now in relation to this litigation? So, if a foundling is not natural born, if the Congress cannot even say that a foundling is disputably presumed, what type of law were you thinking of when you repeatedly told this court that, we should not decide this case because the remedy of the petitioner is with the Congress?
Your Honor, may I first clarify that my earlier statement was to the effect that the Congress cannot even disputably presume that a foundling is natural born. To answer your question now, Your Honor, the Congress of the Philippines may remove the prohibition of certain statutorily prescribed positions as to be occupied only by natural-born citizens to be open to foundlings, including those positions enumerated by the Honorable Chief Justice, Your Honor, excluding perhaps national positions and justiceship in the Supreme Court of the Philippines. It should be, I believe, always reserved for natural born. The law now, Your Honor, prohibits...
So I understand your point,
Yes, Your Honor.
Commissioner Lim. I think what you're saying is to the fact that there are many, that in the Constitution, there is a limited number of positions reserved for natural born, right?
Yes, Your Honor. And there are also laws.
No, on the Constitution muna. Don't go into laws.
Yes, Your Honor, yes.
And can you enumerate this again?
All national positions up to congressman, Your Honor.
And members of this court, right?
Members of the judiciary, Your Honor.
And members of the Constitutional Commission.
Yes, Your Honor, including members of the Philippine Bar.
Now, so, limit yourself to that. Your statement that there is a remedy in Congress applies only to the other positions. But with respect to the constitutional positions named, there is no remedy.
There is reasonable basis for classification, and therefore, the equal protection of the law clause is not offended, Your Honor. That is my humble submission. Because, Your Honor, please.
Can I repeat my question? For example, and limit it to the case of the petitioner or limit it to the case of justices of the court.
Yes, Your Honor.
Your interpretation of the Constitution is that a foundling is not natural born.
Yes,
right?
Your Honor.
And you're saying not even the Congress can have another view, because if they have another view, they must follow what you said is the view, correct view, because that is, according to you, that is what the Constitution says.
The Constitution is the fundamental law, Your Honor.
Therefore, when you interpret the fundamental law to mean that foundling is conclusively presumed to be an alien except if he or she can give DNA evidence, there is nothing that the legislature can do.
I beg your pardon, conclusively presume that a foundling is an alien, Your Honor? Is that the question? I'm sorry, Your Honor.
Can I rephrase the question?
Yes, Your Honor.
At the last hearing, you seem to give the impression that the remedy that the petitioner Poe, can seek is not from this court, but from Congress.
Remedial legislation. Your
Yes, remedial. That's why I'm asking you, if, as you say, there is the parentage of a foundling can only be shown by DNA evidence, what kind of remedial legislation will suffice?
Your Honor, I earlier mentioned to Your Honor that one possible remedial legislation would be to open up positions in government that are reserved for natural-born citizens, not by the Constitution, but by law, open them up to foundlings as well. Now, applied to the case of the petitioner,
No, that will be fine, counsel, and maybe you can just explain that in your memorandum. Because I have a next question.
yes, Your Honor.
The power to lay down rules of court is vested in what branch of the government?
In the Supreme Court, Your Honor.
Can the Supreme Court amend the rules of court to provide for a disputable presumption of natural-born citizenship in the case of a foundling?
Well, Your Honor, to really answer the question, any lawyer would beg off to say that he would really study this matter. But offhand, my respectful answer to Your Honor is that not even the Honorable Supreme Court can issue such a rule because the effect would be to contravene the Constitution, its plain language and meaning.
So, if a majority of this court disagree with you on your reading of the Constitution, suppose 8 or 9 or 10 justices of this court disagree with you and say that your proposition that foundlings are not natural born is not correct, will you follow that ruling of the court?
Of course, definitely. We bow down always before the majesty of our Supreme Court, Your Honor. Even if personally we may have reservations, but as lawyers we are trained to accept Supreme Court rulings, Your Honor.
So you concede that at the end, as they say at the end, you will have to convince this court that your interpretation is the correct interpretation based by what you say, what you plainly see as verbal legis. You need at least to convince 8 or more justices of the court that they agree with your point of view.
Yes, Your Honor. But if Your Honor will allow, may this representation just bring the discussion, if I may, to the main issue before the court and to refocus it to such an issue of grave abuse of discretion on the part of Comelec in ruling not only on citizenship but also on residency.
We will come to that, Counsel.
Yes, Your Honor.
And it's good that you discuss because I will come back to grave abuse later on.
Yes, Your Honor.
Now, my next question is, did petitioner Senator Poe tender a triable issue as to whether or not her parents are citizens?
Yes, Your Honor, by claiming that as a foundling, she was natural born. And if you consider that claim vis-a-vis Section 78 of the Omnibus Election Code, it was a triable issue, although Section 78 proceedings are summary in character, Your Honor.
So you concede, Counsel, that the issue of fact of the parentage of petitioner Senator Poe is a triable issue of fact.
Not triable in the judicial sense, like in a court of justice, but it had to be considered among the totality of evidence in determining material misrepresentation.
So
Under our mandate, Your Honor.
it is a triable question by a quasi-judicial agency, just like the Comelec, which is a constitutional commission.
Yes, Your Honor, but Section 78 is summary proceeding, Your Honor.
Yes, certainly, and we will come also to that,
Yes,
that it
Your
is
Honor.
summary. Now, and again, I will do a very brief exercise with you, just to make sure, and that for the record, that it was indeed a triable question of fact, because now it is clear. After that, I will go back to show with this as a triable question of fact. I will go back again to your decision, both bank decisions, because I keep looking, it seems to me you did not make findings of fact.
We made findings
Now,
of facts, Your Honor.
let me go through you, and again, if at any juncture it doesn't ring a bell, you can ask one of your associates to bring you the pleading.
Yes, Your Honor.
And for this exercise, I will use the Tatad petition, because I had already adverted to what was the allegation of the I am using the Tatad petition because I think I cited already the allegations of the Elamparo petition,
Yes, sir.
and then the other petitions did not raise issues. So, Tatad petition, the allegation is paragraph 2.2, Poe is a non-Philippine national at page 6. 3.1, on September 3, 1968, she was found at the Haro Parish Church by militar, and Tatad presented as evidence the birth certificate as Annex A. 5.1, the allegations of the Tatad petition, Poe lacks citizenship, having no known, at 5.2, having no known parentage, it cannot be determined if she was born of a Filipino father or mother, and therefore, hence, she is not a Filipino natural-born citizen.
Yes, Your Honor.
Now, I will go now to the verified answer of Petitioner Poe. Under Section 1, averments, the allegation is respondent Poe does not know who her biological parents are. She was born September 3, 1968 in Haro, Iloilo. However, immediately after her mother gave birth to her, she was abandoned in a parish church of Haro by a certain Edgardo Militar. They also cite the same birth certificate. Now, Roman 2 of the Poe verified answer is specific denials. 2.1, they specifically deny the second and 10 paragraphs which states that Poe lacks Philippine citizenship. Now, 2.4, specific denial. And I will quote, the allegation in paragraph 2.2 of the petition that respondent is a non-Filipino national is denied. In fact, denied is all capitals. Is denied for being false. The truth is that respondent is a natural-born Filipino as explained in the averment and in the defenses. So
Yes,
far,
Yes, Your
so
Honor.
good. Now, in the affirmative defenses of the verified answer, and again, I'll do this very quickly, the allegations are as follows. Respondent is a natural-born citizen of the Philippines. Though foundlings are not expressly mentioned in Section 1, Article 4 of the 1935 Constitution, intent of the framers to include them is evident. Now, paragraph 4.34.2, and I quote, respondent is only 5 feet, 2 inches tall. See Annex 4. Annex 4 is, I think, one of her passports.
Yes, Your Honor.
Now, paragraph 4.34, there is no dispute that respondent was found as a newborn baby in Iloilo City, which is located in the Philippines. In 1988, as at any time, an overwhelming majority of the population in Iloilo City were Filipinos.
There is a claim to that
Allegation.
effect, Your Honor.
That is the claim of fact. That is the allegation of fact in the affirmative defenses.
Yes,
Right.
Your Honor, that is claimed there.
Now, it is also claimed as a fact or asserted as a fact by Petitioner Poe 4.34.5. There is no question that respondent was abandoned in a Roman Catholic church. A great majority of Filipinos are Roman Catholic. Even in 1968, the Philippines was the only predominantly Roman Catholic country in Asia.
Yes, Your Honor, there is that allegation.
There are those allegations of fact, right?
Yes, those are allegations of facts, Your Honor.
Now, 4.34.6, newborn babies are abandoned usually because their parents are poor.
That is a conclusion, Your Honor.
A conclusion, but also an allegation of fact. It says newborn are abandoned usually. Okay. Now, 4.34.7, Manila, which is closest to the international airport. Manila is closest to the international airport compared to Haro, Iloilo. It's an
Yes.
it was alleged as a matter of fact, right?
Yes, Your Honor.
Now, 4.35.1, there have been many Filipino parents who have abandoned their children. That's an allegation of fact.
Yes, Your Honor.
Now, I do not think that there was a reply filed to the verified answer.
There was no
None.
reply, I believe, Your Honor. Just
There was none. But then the seasoned litigator that you are, we know that even if there is no reply, all the matters stated in the verified answer are deemed controverted, right?
Controverted by
So-
the non-filing of the reply.
Even if there is no reply.
Yes, Your Honor.
Therefore, all of these questions of fact were raised by Petitioner Poe, right?
Yes, Your Honor.
In addition to her allegation that she is a foundling, right?
Yes, Your Honor.
Now, the allegation that she is a foundling was stipulated to by all the other respondents, right?
That is correct, Your Honor.
So, My question now is, there seems to me that beyond the stipulated admission that she is a foundling, Petitioner Poe, in her verified answer, tendered allegations of fact which, to their mind, will prove that she is a natural-born citizen.
As a matter of fact, Your Honor,
And now my question is, where in the two en banc petition, in the two en banc resolutions of the Comelec, did it make a finding of fact based on the other evidence presented by petitioner that Petitioner Poe is or is not natural born? In fact, what you seem to have done in both petitions and in the Tatad petition is you only ruled as a matter of law that she is not natural born because of your reading of the Constitution, right?
Your Honor, please, we made findings of facts. As a matter of fact, there was even no need to make findings of facts because there was a stipulation of facts.
Can I stop you first, Counsel,
Yes, sir.
and with all due respect? Did you make findings of fact, or you did not have to make findings of fact?
We made certain findings of facts.
Show me in the resolution on the foundling issue. Where is your finding of fact?
Your Honor, please, we made the finding of fact that notwithstanding the claim that she was found at the doorstep of the Harrow Church, which is admitted by both sides, notwithstanding that the petitioner was presumably born in Iloilo because she was found in Iloilo, and the presumption would be that that would be her place of birth. Still, we reached the conclusion that despite all this totality of facts stipulated at that by the parties, the facts, independently or collectively, do not satisfy the constitutional definition of what is natural born. If Your Honor is saying that each and every piece of allegation had to be frontally and directly dealt with in each and every paragraph of the decision, in the same way that each and every piece of evidence had to be recited as to probative value or absence of probative value, I would respectfully disagree. Because of the disputable presumption, which has not been overcome by the petitioner, that all the issues presented in a case or involved in a case are deemed to have been laid out before the court, and the court, in rendering a decision, is disputably presumed to have considered all the facts, all the allegations, and all the totality of the evidence. A judge, Your Honor, is not required by any law or by the Constitution to discuss in detail each and every piece of evidence. The fact that a particular conclusion is reached, like Coquilla, reestablishment of domicile can only come about upon repatriation. That finding immediately disputed and contradicted the claims that buying a lot in Corinthian, enrolling her children in Philippine school, sending her belongings to the Philippines, established residence. So the citation of a jurisprudence on a particular issue is in itself a ruling on those allegations of facts. And besides, Your Honor, please, there is here in our resolution, for instance, this is the consolidated en banc resolution on the Tatad, Contreras, and Valdez cases. I respectfully invite your attention, Your Honor, to pages 2 up to 6 of said assailed resolution. In the second paragraph, it says, the facts as found by the First Division are undisputed. And then it went on to make a very lengthy recital of the facts. The facts as found by the First Division. How the facts is approached by any particular judge is perhaps a matter of style. What is predominantly important is that the two assailed resolutions satisfy or should satisfy only one requirement, I respectfully submit. And it is the constitutional requirement that every decision of a court, including a quasi-judicial body, should set forth distinctly the facts and the law upon which it is based. It cannot be a decision with just a simple conclusion. The findings must be set out, the issues must be discussed, and the ratio or palio must be stated. Everything
Thank you, Counsel. And now, what you read there is that is the consolidated petitions, Tatad, Elamparo, and Valdez, right?
Yes, Your Honor.
That ruling of the en banc.
In my own division case, which is the Elamparo petition, we made similar findings.
No,
And it is recited in the en banc also.
I was asking you to show me the statement where there was a finding on the evidence to prove or disprove natural-born citizenship beyond the mutually stipulated fact that she is a foundling.
Yes, Your Honor.
Now, I am saying I cannot find any. For example, now, and if I may use the SET decision as a point of comparison. Now, the SET decision is part of the records of this case. I think it was submitted by Petitioner Poe. In fact, the transcript of the SET hearings is part of the records of this case because it was appended to by the Tatad petition. And a while ago, you cited an opinion of one of the justices in the set opinion. My point, counsel, if you put side by side the set opinion, your two en banc opinions, the set opinion makes findings of fact on whether beyond the foundling admitted stipulation, whether the evidence presented as to where Harrow is, what is the color of the skin, what is the color of the eyes, made specific findings to arrive at the decision that in their view, Petitioner Poe here, in that case, is natural born. The Comelec did not do that. That is why when I read and have reread it, my impression is because you are decided on a question of law, foundling, ergo, not natural born. That's why I'm asking for a specific finding beyond the statement stipulated that she is a founding. Because that to me, the stipulation that she is a foundling is the starting point. Petitioner Poe entered into record allegations stating other facts, her color of her skin, her height, her eyes, where she was born, whether there was an international airport or not. Obviously, she was arguing in the argument portion certain arguments out of these facts. If I looked and I have read and reread the two en banc resolutions of the Comelec, I cannot find you, the Comelec, making a finding of fact on those matters.
May I reply now, Your Honor? May I answer? Thank you, Your Honor. Excuse me, Your Honor. We made, excuse me, Your Honor. We made findings of facts. Let us go to specifics. But before going to specifics, let me further qualify that statement. We made findings of facts, and there were facts which was no longer necessary to be found, being admitted. Let us now go to specifics. Allegation number 1 of the petitioner, that the petitioner is only 5 feet 2. No need to make such a finding as to her height. Admitted. That she was born, excuse me, Your Honor, that she was born in Iloilo. Admitted. That majority of the inhabitants of Iloilo are Filipino citizens. Admitted. That the Manila International Airport, where foreigners could come, is nearer to Manila and farther to Iloilo. Admitted. So everything boils down to a matter of style. But I can tell you honestly, Your Honor, that during our deliberations, and I can vouch for this personally because I belong to the second division, and the two cases, these cases were again deliberated upon in the en banc. We discussed all that nitty-gritty. But the writer of the decision, we all have our own writing style, Your Honor, and I will not equate myself with the justices. But judges write and present facts differently. Why would it be necessary, Your Honor, with all due respect, for us to say that we should have taken the height measurement, the height of Senator Poe, or conducted a population census of Iloilo? No need, with all due respect. These are admitted facts. Despite all this being admitted facts, the question remained, as foundling, is she natural born? That is the focus. And when we found that she is not natural born, did we commit abuse of discretion, and gravely at that? That is the issue that I would like to submit to the Honorable Court.
Go to my next question. Now, I don't remember now which of the two en banc decisions said to the effect that, I think it said something like, and the unfairness, or I think the word used by the en banc, I don't know now which one, and the absurdity of the petition will be shown if the claimant, or if the foundling is, I think, blue-eyed, green-eyed, blonde. Do you remember that?
There is such obiter. I would call it an obiter, Your Honor.
Now,
because the color of the eyes would
before
not
you
matter.
go, can I make a statement, Counsel? That is why I think, and with all due respect also, you were obliged when the Comelec said it is absurd to consider Poe because it would be different if the petitioner or some other claimant is blonde, green-eyed, I think, or blue-eyed. The Comelec was in effect saying we will have to decide this case on a case-to-case basis. And here, what you were confronted was a person who is, complexion is brown, her height is only 5 something, and she is not blonde, and she is not blue-eyed or green-eyed. That to me shows that you concede that there is a triable question of fact. Because if that were the evidence, then you could have made a decision. But you did not make, and still to my mind, and you can cover it in your memorandum, to my mind, you did not make a factual determination based on the evidence.
With all due respect, Your Honor, the premise of the question, and I again say with all due respect, is based on a fallacy, if I may say so, with all due respect, Your Honor, because we have Filipinos who have blue, green, and gray eyes, not only brown eyes. We are now a mixed race, Your Honor. That's why I earlier commented, perhaps that kind of statement might just be obiter, a literary flourish. But at the end of the day, what is really primordial is, despite all of these facts, despite all the allegations tendered by the petitioner, we still had to grapple with the question, assuming all these facts to be true, as in fact they have been stipulated upon, is a foundling, the petitioner, a natural-born citizen. And we made our ruling accordingly, and we are here to be judged by the Honorable Court on whether we committed grave abuse, Your Honor.
Thank you, Counsel. Now I think, because I may not have been, it may not have been clear to me, you are now saying that beyond the statement that Petitioner Poe is a foundling, all the other allegations of fact, Iloilo, where it is, you are stipulating to it?
The stipulation is in the decision, and we stand by. The judge cannot make a stipulation. The parties stipulated, Your Honor, and the facts as found by the Comelec is based or are based on the stipulation of the parties.
Thank you, Counsel. And I would like you to cover in your memorandum, still my nagging doubts on whether you, the Comelec, made findings of fact. You mentioned now totality of circumstances. I still am saying the petitioner are saying that beyond her being a foundling, the totality of circumstances to which you now say you are stipulating prove that she is a natural-born citizen. I do not find
Your
it.
Honor. No, Your Honor, please.
I do not find it in the two en banc decisions, and will you kindly cover it in your memorandum?
Yes, Your Honor.
Now,
Yes,
I move to another area, which is a very critical area of your decision. The applicable provision of the 1935 Constitution and the enumeration of who are citizens.
Yes.
Does it contain the word foundling?
No, it does not, Your Honor.
Your theory is because it does not mention foundlings, ergo foundlings are not natural born.
No, Your Honor, that is not the Comelec's theory.
What is the Comelec's theory?
Comelec's theory, not a theory, Your Honor, but it is a finding of what the Constitution says. The Comelec, the Commission found, Your Honor, that on the issue of citizenship, the plain and literal language of Article 1, Section 4 of the 1935 Constitution, which is the Constitution applicable to the petitioner, speaks for itself. And where the language is clear, only application is required. Interpretation is not allowed, Your Honor.
I understand, Counsel, and that is what I have been repeatedly trying to convey to you. And I respect the reading of the Comelec. Your reading is that because foundling is not mentioned in the Constitution, therefore it is excluded. That is your reading, and you say it is verbal legis, it is plain for everyone to see. That is your, as you say, it is not just your theory, that is your reading of the law, right?
Can I add, Your Honor?
And yes, you can add.
The word foundling might have been there. The word foundling might be in the Constitution now. Had the idea of Senior Raffles been adopted, unfortunately, he was voted down by the Constitutional Convention. There was an attempt to put in the word foundling.
Counsel. So that in the interest of time, again, and I respect the position of the Comelec, but that isn't that the issue now what is the proper reading of the Constitution? The fact, I will say to you, the text of the 35 Constitution does not contain the word foundling. And therefore, textually, you cannot claim that foundlings are not natural born. I'm just saying, textually, what you are invoking is, if we read the history of the text, if we read what transpired during the Constitutional Convention of 1934, it will lead you to your conclusion, right?
Our position, Your Honor, is that the,
And I
the
know.
word foundling need not be found, need not be specifically stated, because the Constitution is clear on the issue, Your Honor.
And I have heard both sides argue it. Petitioner Poe and the Solicitor General in the said case have taken a position, a reading different from yours. Is that right?
Well, we respect their views.
And I respect also your views, and that's why we
Thank
are
you, Your
here,
Honor.
because the court has to decide.
Thank
But
you, Your Honor.
what I think I'm trying to impress upon you is that that is your view, right?
It is the Commission's view, and it is grounded on the Constitution, Your Honor.
And that is something that you have to convince a majority of this court, right?
We hope we can do that.
And I am asking you in your memorandum, it is a big matter to me that your interpretation attempts to be a textual interpretation, but the word foundling is not found in the Constitution.
We can very well discuss that very authoritatively in our memorandum, Your Honor.
Because the contending sides have different interpretations of the meaning of when the Raffles, I think, suggestion was voted down. One side says it was voted down precisely helps their case. You say the fact that it was voted down precisely helps your case. That is why we have a case before the court.
Yes, Your Honor, and that's why we have the Supreme Court, Your Honor.
The Supreme Court will be the one to referee which of these two positions are right.
We always bow down before the majesty of the court, Your Honor.
Now, my proposition to you is that the Constitution is silent about how to, the Constitution textually is silent about how to treat foundlings.
There is the principle of exclusio unius, Your Honor.
Now, exclusio unius is exclusio alterius,
Alterius.
is a aid to construction, right?
Yes, Your Honor, but there is even no need for that, because the plain language of the Constitution speaks for itself, Your Honor.
Verba legis, or plain language, is also an aid to construction, right?
It is.
What is plain to you may not be plain to another. That is why you have lots of cases on statutory and constitutional interpretation.
Yes, Your Honor, the critical point and the critical factor is whether it is plain to the Honorable Supreme Court.
What I suggest to you is, it is not plain to me that the word foundling is found in the Constitution. And therefore, it is not plain to me that because it is not there, I necessarily have to agree with your conclusions. That is why we have a case.
Yes, we respect your views fully, Your Honor.
Now, in fact, the reason we have a controversy is that Petitioner Poe was invoking international law right.
Correct. Yeah, that is correct, Your Honor.
And I will not go into that because I have heard already the pros and cons. Okay. In fact, at a certain point, you must have heard, there is a debate about, well, how many countries exactly acceded to what convention, and how many countries are jus soli and how many countries are use sanguinis, and can you use soli with mixed sanguinis, right?
Yes, Your Honor.
And what is also difficult is, depending on what side, they have different counts. There's a different count by one side on how many acceded to what convention, and there's a different count by what side. I am just trying to tell you that, again, when you have a question of constitutional interpretation, you may have to go to text, you may have to go to constitutional history, you may have to go to constitutional or statutory construction, verba legis, exclusio unius, and all of these are aids to arrive at a principled decision. That's why I am telling you, you have to convince a majority of the court that your position is right, that it is as plain as you see it, because that is why we have difficult cases, because what is plain to you may not be plain to a majority of this court.
Your Honor, please, with your kind indulgence, can I put it in this manner? It is the duty of the petitioner to convince the court, the Honorable Court, that the Comelec committed grave abuse of discretion. That is the cardinal issue.
Thank you,
in this
Counsel.
proceedings, Your Honor.
I think we had a sufficient discussion of that the last time. Now, in fact, who was your professor in constitutional law, Counsel?
The late Chief Justice Concepcion and also Irene Cortez, Your Honor.
Well, in my case, my professors were the late Froy Bakungan, and I had the opportunity to be under former Assistant Solicitor General and later a member of this court, Vicente V. Mendoza. Now,
Yes, Your Honor.
I will share with you a quote which was a favorite quote of Justice V. Mendoza when he was still an Assistant Solicitor General. I think the context was remember the case of the ratification cases?
Yes, Your Honor.
What is the title of the case?
I forgot now the name, Your Honor. The ratification cases of the Constitution.
Where so many,
Yes, Your Honor.
almost everybody wrote opinions, and in the end, there was a controversy on what exactly did the court decide. And then ASG, Vicente Mendoza, and later Justice, will regale us in that course on advanced constitutional law. He had a favorite quote from Paul Freund, who was his favorite constitutional scholar. And of course, the materials that he gave us from Freund really came from Thomas Reed Powell. He is a famous law professor, Thomas Reed Powell. And he said, and I quote, "The social sciences are a field where the counters don't count and the thinkers," no, I'm sorry. "The social sciences are a field where the counters don't think and the thinkers don't count." I'll repeat it. "The social sciences are a field where the counters, those who count, don't think and the thinkers don't count." And it seems to me that this quote, which I got from Justice Mendoza, is so appropriate for this case. We are counting how many countries, we are counting how many aids to construction, and we may seem to be missing the point by saying, we count countries, we count how many participated in the Constitutional Convention. And therefore, I am suggesting to you and I will refer to you an article, and I will give you the citation of Professor Larry Tribe. And the title of the article is Toward a Syntax of the Unsaid, Construing the Sounds of Congressional and Constitutional Silence. I will repeat the title of the article of Tribe. Toward a Syntax of the Unsaid, Construing the Sounds of Congressional and Constitutional Silence. You can find it at 57 Indiana Law Journal 515, 1982. And then it's very interesting reading, Counsel. Now,
Thank you for that, Your Honor.
now and just as a point of interest, this article was taken up in the fall seminar of Professor Tribe in the fall of 2015. He handled the course entitled Constitutional Silences, the silence of the Constitution. So his article was about the sounds of constitutional silences. And prominent in that article was his quote from Justice Jackson of the United States Supreme Court. What Justice Jackson called, and I quote, the great silences of the Constitution. So what I propose to you is that this is a very difficult case because there is a great silence by the Constitution about what to do with foundlings. The Constitution does not contain the word foundlings. It does not tell us what do we do. It does not tell us what type of evidence. And you have staked a position, and the petitioners have staked a position. So, the theme of Larry Tribe, when we are confronted by a problem about the silence of the Constitution, what do we do? And precisely, you should read the article. He outlined the limitations of adverting to constitutional history. And I think this case falls under it. The record of the CONCON of 34 is not disputed, but two sides arrive at diametrically different conclusions from the same record. So, in short, what did Professor Tribe say? What do you do when you have a great silence of the Constitution? He proposed that then you should not do not look very far. Just look into underlying principles or underlying rules found in the Constitution itself. And I am comfortable with that, and that is why so far, and until the end of my discussion, I will not discuss international conventions. My proposition to you is that this case of whether a foundling is natural born must be resolved by us as a sovereign nation. You don't have to go far. Look for other principles. We must, and you have helped us decide this based on the Bill of Rights, specifically the Due Process Clause and the Equal Protection Clause. And by chance, in fact, if you look at the structure of the Constitution, the Bill of Rights is Article 3 and citizenship follows under Article 4. Now, and I will walk you through what I mean that we must decide and need decide this case only on the basis of due process and equal protection of the laws. We have gone over, I have already said I have grave doubts on whether the Comelec complied with the constitutional provision that you make findings of fact and law. But you covered that in your memorandum. Now, I go now to due process. My grave concern is that by the way you decided and banked in the two petitions, you may have, and I think you have deprived Petitioner Poe of her due process right to have her claim to natural-born status dismissed without considering the evidence. That is my proposition to you, and we will go back to that later. Now, let me walk you through. Why do I say that? The rules of court, counsel. Section 128. Section 1, evidence defined. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. The truth respecting a matter of fact. Now, I know you have qualified that you are not, that the Comelec is not a court of law in the judiciary act way, but you will agree with me that rules of evidence, you have your own rules. Rules of court evidence will be supplementary.
That is correct, Your Honor.
Now, this, and I will go now to due process. No, and I will go now to the issue of fact. Isn't the issue of fact that was brought before you, which needed an ascertainment of the truth, was who is the biological father or biological mother of Petitioner Poe?
That is not the issue of fact, with due respect. The issue of fact that was presented before the Comelec was whether or not the petitioner was a foundling. That is the thrust of all the petitions.
And again,
She is a foundling. Just with due respect, may I just explain, Your Honor? The thrust of all the petitions was that the petitioner being a foundling is not natural born. That is the issue of fact tendered in the petitions. The verified answer of the petitioner, right in the opening paragraph, started this way. Senator Poe is a foundling with unknown biological parents. So the issues were joined. There was no need to inquire into whether or not she was a foundling.
you don't.
Because that was admitted by both sides. And it requires no further proof, Your Honor.
In the interest of time, counsel, I understand what you are arguing, and I think do it in your memo so that I can proceed. Now, but it seems to me that the underlying question of whether there is material misrepresentation with respect to her citizenship is the question of whether she is natural born or not.
That is correct, Your Honor.
This provision of the rules of court that evidence is the means sanctioned by the rules of ascertaining the truth respecting a matter of fact, does this have constitutional basis?
Of course, Your Honor.
And why?
Because every decision of a court of record, including administrative bodies, is required to set forth therein clearly and distinctly the facts and the law upon which it is based. That is not an ordinary rules of court provision. Pardon me for using the word ordinary in referring to the rules of court. It's promulgated by our Supreme Court. I just wanted to highlight that that is a constitutional requirement.
And I cannot agree with you more, counsel. Now, but my question is there a due process basis for this provision of the rules of court? Or for that matter, now that you think about it, the whole body of the law of evidence. We go to law school and learn what is evidence.
Yes,
What
Your
is
Honor.
the constitutional basis that when you ascertain the truth respecting a matter of fact, you are guided and you must use the evidence or the rules of evidence as laid down by the Supreme Court in the rules of court?
Not in every situation is evidence, oral, testimonial, or documentary. Not in every situation, Your Honor, please, is evidence required to be presented on matters of judicial notice, on matters of facts duly stipulated. There need not be evidence anymore because there is now proof. Proof is the effect of evidence. And the evidence is arrived at by ascertaining the facts. And when the facts are already stipulated and admitted by both sides, there is no more need for ascertainment. That is the position we have taken, Your Honor.
Again, I could not agree with you more, counsel. I go back to my question. What is the due process basis for requiring that in the ascertainment of truth, evidence must be used? The evidence prescribed by the rules of court. I will tell you my view. I will quote from you to you from George Sutherland, a Supreme Court Justice of the United States, from the case of United States versus Provident Trust, 291 U.S. 272, and I quote, "It is a fundamental requirement of our system of law that questions of fact must be resolved according to the proof." End of quote. And we agree, we both agree on that.
Yes, Your Honor, but perhaps...
Yes, and there is no question yet.
Yes, Your Honor.
So that in the interest of time, because we are under time pressure. Now, proof is the synonym of evidence, right?
Effect of evidence,
Yes,
Your
it's
Honor.
the effect or the effect of evidence. Now, I have heard your position on what is the issue of fact. I say to you, the underlying issue of fact, when you go to the Comelec to disqualify based on material misrepresentation, is whether a foundling is a natural born citizen. Now, you go now to Section 3, also of Rule 128, and I'm sure you know this by heart. Evidence is admissible when it is relevant to the issue and is not excluded by the law or these rules, right?
Relevancy and competency, Your Honor.
Now, we're still just on relevancy. Now, I say to you again, on the matter of proving whether a foundling is natural born, all types of evidence should be admissible.
Yes, Your Honor.
Now,
Unfortunately,
no, I have no question yet.
yes, Your Honor.
And in fact, I go back to your proposition that in this case, citing a dissent in the set, the only evidence, though, that will be admissible is DNA evidence.
I will not foreclose other forms of secondary evidence if relevant and competent.
Okay.
But we have to see if it is presented before us, Your Honor.
So, the other relevant evidence would be, for example, where Harrow Parish Church is situated.
But the question is whether it will be adequate evidence, Your Honor.
And now, you are saying all of those matters I recited are admissible. In fact, you are stipulating to it. You are just raising that in the end, they are not sufficient.
Because we have the rule on quantum of proof, Your Honor.
Yes, and because you have the room of control proof. But I go back again, I cannot see in your discussions in both en banc decisions explaining why they did not meet the quantum of proof. my recollection is you just kept saying, because of verbalages, because it is plain, therefore a foundling cannot be.
With due respect, Your Honor, we discussed the need for substantial evidence. We discussed the allegations about reestablishing domicile as allegedly proven by...
I'm not, Counsel, as I said, my line of questioning is limited to the foundling issue.
Yes, Your Honor.
And so if I may continue, the rules of court, the evidence, do not, you concede now, in fact, do not say that only DNA evidence is acceptable.
There are many types of evidence,
many
but
types.
whether admissible or not is another issue. Whether relevant or competent is another issue, Your Honor.
Now, I will go now to the last provision that I will quote from the rules of court. And that is still on Rule 128, Section 4. I think you mentioned relevancy.
Admissions by a party, Your Honor.
No, it's Section 4, 128.
I'm sorry.
Relevancy, Counsel. Evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue.
Yes.
Therefore, relevant, they are admissible, and then to the trier of fact, and you were the trier of fact, the Comelec and Bank was the trier of fact, all of these pieces of evidence which you consider admissible should enable you, as the trier of fact, to induce in you a belief in the existence or non-existing existence of the matter of fact. So all of this evidence are laid out so that they will hopefully induce a belief in you on the matter of fact, on whether the parents of the foundling are Filipinos.
Yes, Your Honor. Yes.
And given again what you said is the totality of the evidence to establish the probability or improbability of the fact in issue. Again, the fact in issue is who is the parent, who are the parents of the foundling.
The fact in issue is whether a foundling is a natural-born citizen, Your Honor. Your Honor, please.
Yes. Now, before, can I finish, Counsel?
Yes, Your Honor.
I think your statement, the fact in issue is whether
A foundling, as admitted by both sides, is a natural-born Filipino citizen.
But before you can go into natural born, you have to establish first who is the parent, right?
It was not our burden to establish who the parents are. It should have been the burden of the petitioner to do so. I mean, the private respondents now here. But that burden was discharged when the petitioner now, Senator Poe, admitted that she is a foundling.
And now, Counsel, I will go to a second due process point where I think the Comelec may have crossed the line and may have violated the constitutional rights of the petitioner.
We vehemently deny that, Your Honor. We observe due process.
With all respect, Counsel, I have no question yet.
I'm sorry for that, Your Honor.
I said that is my view.
Yes, Your Honor.
And it's a tentative view because at the end I will ask everybody to please cover it in the memo.
Yes, Your Honor.
Because I believe the due process clause was not sufficiently covered in the previous question and the previous interpellations.
Yes, Your Honor, but will you allow me to state the Commission's concept of due process, Your Honor?
Yes, but can I ask the questions one by one?
Yes, Your Honor.
Now, the use, when you say that the petitioner has only one type of evidence that can prove her parentage, and that's only DNA.
Seemingly for now.
And what is the meaning of seemingly for now?
That is what a reasonable mind could possibly approximate. Because we have a situation where a child is of unknown biological parents. From the premise that the parents are biologically unknown, it cannot admit of proof that parentage exists. Identity-wise, that is. Otherwise, the parents would be known. So in a situation such as this, Your Honor, it is our respectful submission that some other modality other than the surfacing of the parents, other than evidence of family relations, one plausible evidence would be what Justice Carpio suggested, DNA. And although we did not discuss that in our decisions not being necessary anymore to a disposition of the issues before us, this humble representation accepts that suggestion to be very sound. Because, in all fairness, a foundling status need not be attached to a person forever.
Now, I have a question, Counsel. You did not use the word you did not use the term that a foundling is conclusively presumed to be an alien. You did not use that.
There is no such, the document will speak for itself, but to the best,
No,
to the best of my recollection, there is no such statement.
I agree with you, Counsel. I'm not saying that you did. I'm just saying
Yes, Your Honor.
there is no, you did not. Right?
Yes, Your Honor.
Now, what bothers me is that when you say now that a foundling can prove it by DNA evidence, aren't you in reality saying that that is really a conclusive presumption? Because in the first place, the foundling doesn't know his or her parents. So how is he or she supposed to find a DNA match when the very definition of foundling is somebody who has unknown parents?
As of the present time. And by the way, it is not can prove it, may prove it by DNA evidence. But it is a big question mark, Your Honor. That is the tough nut to crack. Whether DNA evidence could in fact be found and could in fact establish according to the parameters laid down in a court of law. And the court may please take judicial notice of announcements in media that petitioner has in fact initiated such efforts. But to date, unfortunately, it is negative. So that is where we are, Your Honor, please.
Now, again, I will cover it in your memorandum. It really bothers me that while you are not staking a claim that foundlings are conclusively presumed to be aliens, it bothers me that effectively you are, because I am bothered by your saying, for now, Oh, when is the time for a foundling to be able to prove that she has who her parents are as to get to a DNA test? When I say, by the very definition of a foundling, he or she doesn't know. Do you have evidence that foundlings at a certain point, the parents just come out of the woodworks and say, I am your parent?
With your kind indulgence, Your Honor, I suggest we go back or we go to the nature of the decision process making of courts and of quasi-judicial bodies. We decide based on the evidence before us, based on the issues before us, based on the facts established before us. We cannot go into extraneous matters or suppose things to exist when actually they do not, because the truth in a judicial proceeding is not necessarily the truth in actual life. A horse may actually be colored black,
I can,
but witnesses can prove that
Again.
it is colored white.
again, I cannot agree with you more, counsel. Can I ask my next question?
Yes, Your Honor.
Now, the reason that conclusive presumptions are not favored, even in evidence, and I'm saying again and cover it because from where I sit, I have a feeling that whilst, again, as I say, you're not saying you're advancing a conclusive presumption, in effect, what you are arguing for is a conclusive presumption. Now, and I know you have a different view, and you will cover it in your memorandum, and I will tell you why, in the law of evidence, conclusive presumptions are not favored. Number one, conclusive presumptions are, according to the treatises Wigmore, Jones, they are counterfactual. They are counterfactual. A conclusive presumption is counterfactual. I'll give you a hypothetical, and I will leave the blank. Because the student went to the blank College of Law, he or she will surely pass the bar.
That is a fallacy, Your Honor.
Yes, that's why you cannot have a conclusive presumption that because somebody went to whichever College of Law, he or she will pass the bar.
But we have Rule 131 of the Rules of Court on presumptions and burden of proof. And there are two instances of conclusive presumptions mentioned therein. Estoppel in pais or estoppel by conduct and landlord-tenant relationship, Your Honor.
And again, counsel, you are such a seasoned litigator. I cannot agree with you more. I am impressed by the way you can cite the rules of court. But I am not yet there, no?
Thank you, Your Honor.
Andito pa lang ako sa... Now, the other objection to conclusive presumption is that they, and I quote, presumes a fact which is not necessarily or universally true. Again, I will quote to you. Conclusive presumptions, quote, presume a fact which is not necessarily or universally true, end of quote. And I agree with you, there are only two conclusive presumptions in the rules of court, right? Now, a child has a biological father and a biological mother, right?
Yes, Your Honor.
And a foundling is a human being.
Of course, Your Honor.
And so therefore has a biological father and a biological mother.
Only that unknown.
Yes. Now, and that is our problem. Their
Yes, Your Honor.
parentage is unknown. Di ba?
Yes, Your Honor.
Now, I will give you 4 possibilities, and at the end of the enumeration, I will ask you if I had missed another or more possibilities. A human being, a foundling, the biological father or the biological mother could be Filipino. It's possible.
Yes, Your Honor.
So that's the first possibility, that the parents of a foundling are both Filipinos.
Yes, Your Honor.
The father, the biological father of a foundling could be a Filipino, but the biological mother of that foundling could be an alien,
A foreigner. Yes,
or
Your
foreigner.
Honor.
That's the second possibility.
Yes, Your Honor.
The third possibility, the mother of the foundling is Filipino, but the father is alien.
It's a possibility, Your Honor.
And the fourth possibility is both biological mother and father are aliens.
It could be also, Your Honor.
It could be. Now, I gave you four possibilities. One, both mother and father are Filipinos. Two, father is Filipino, mother is alien. Three, mother is Filipino, father is alien. And four, both mother and father are aliens. Now, in the case of a foundling, can you tell me, is there a fifth or sixth or seventh possibility?
Science may not admit of a fifth or sixth possibility, Your Honor.
Like?
Biological procreation may not, unless there is artificial insemination.
But counsel, and I think though both of us, when we took our civil law, there was no family code yet, right?
I beg your pardon, Your
When we were both students, there was no family code yet,
Civil Code of the Philippines.
civil code. Now,
The Civil Code of 1950, August 30.
my
1950.
my point, my point, counsel, is that artificial insemination is now covered in the family code, right?
Yes, Your Honor.
But that state of science still brings us back to four possibilities, because the parentage, I guess what you want to say is that the parentage, whether there has to be a biological father and a biological mother, whether the procreation was natural or by other means, like insemination, right? But I go back to my question, do you have a fifth possibility?
Without meaning to be jocular, Your Honor, there are countries now in the world that admit or tolerate same-sex marriages, and sometimes there is a scientific way of producing a child on the part of this kind of couple. My knowledge is not very...
Can I have it again, counsel? You're saying same-sex,
technically could have a child.
yeah, can adapt, but we are talking of the possibilities of procreation. So I two males cannot produce a baby, right? Two females cannot produce a baby, right?
Biologically speaking, Your Honor, but
Well,
not in
that
the
is
modern-
why, yes, of course, biologically. And the question is biological. That's why I kept saying biological father, biological mother. We're not talking about adoption. So again, I go back to my question. Procreation of the foundling, there are only four possibilities
based on biological procreation. Your Honor.
based. And in the four possibilities, in fact, three of them, the first, both are Filipino. That makes the foundling a citizen. The second one, the father is a Filipino. That makes the foundling a citizen, natural born. The third one, the mother, that makes the foundling a Filipino. It is only in the fourth possibility, when both are aliens, that the foundling, as a matter of fact, can be deemed not natural born.
The problem, Your Honor, is that the petitioner has not discharged its burden of establishing before the commission which of the four it falls under.
And I cannot agree with you more. Because how can she establish it when she doesn't even know her father and she doesn't even know her mother?
Precisely, Your Honor.
Now, my point, and I go back to conclusive presumptions. Again, I said I am very uncomfortable with the position you're taking, that they are, and I think if you read the dissent of Justice Carpio in the said case, what he said was, foundlings are naturalized until they can prove by DNA that they are natural born.
Under the Domestic Adoption Act.
Now, what is your position? Is that a correct reading of the Constitution?
A foundling, Your Honor, once registered under the parameters laid down by the Domestic Adoption Act of 2003, is issued a foundling certificate and may be considered already a Philippine citizen because she is put up for adoption. The law is adoption of Filipino children. But the important and critical question is, what kind of citizen? I subscribe to the view that it's only naturalized, not natural born, because of Section 2, Article 4. The need to perform an act to perfect or acquire citizenship. That is the very issue, Your Honor, and that is a requirement. And I dare submit that being in the Constitution, our hands are tied. Not even the Honorable Court can undo what the Constitution expressly commands.
And again, Counsel, you go back to your view of the Constitution, and I forgot to ask. That is why at the last oral arguments, in fact, I believe your view is that only a constitutional amendment can cure the predicament of Petitioner Poe. And what would be that? In what will that constitutional amendment state?
Vis-a-vis natural born status.
What will it
The
state?
Constitution being the highest law.
No, I'm saying
the
now,
fundamental law.
what will the constitutional provision say?
Through initiative, Your Honor, the people can propose an amendment to the Constitution.
No, I'm not. What will the constitutional provision say?
Adopt the idea of Mr. Raffles.
That it
Foundlings.
will say something like this: foundlings are considered natural-born citizens.
In the same manner,
I'm just asking
Yes, yes,
that is the type of
yes.
amendment that you believe will solve the problem or the predicament or the difficulty of Petitioner Poe.
yes, Your Honor, but please allow me to explain. There is no inconsistency
I'm not talking of
with
inconsistency.
if I may, Your Honor, with the performance of an act to perfect or acquire citizenship. Because even under our present 1987 Constitution, under Section 2 of Article 4, after defining what is natural born, the Constitution says those who elect Philippine citizenship under Section 3(1) hereof are deemed natural born, referring to those born before January 17, 1973, date of approval of the 1973 Constitution, who elected Philippine citizenship, Your Honor. So the election of Philippine citizenship is an act. But under Section 2 of Article 4, the people so electing are deemed natural born. So in the same way, Your Honor, please, since I would just respectfully treat this as sort of an academic exchange without committing the commission, then perhaps a form of constitutional amendment would be to say that foundlings are Filipino citizens under natural born under certain parameters. But that is to speculate. We may or we may not have that con, and the issue is now. Now, Your Honor, and we are mandated to decide, and we have decided.
And again, just counsel, I think I heard you say that without committing the commission? Because it is your view, but counsel
Because
precisely...
these are outside the assailed resolutions, Your Honor. This representation is being asked some questions of law, and I do not like to presume that my colleagues will join me in that opinion, Your Honor. But insofar as the questions are within the ambit of the assailed resolutions, I would like to make it of record I speak for the Commission, Your Honor, and I am fully authorized to do that, Your Honor.
Counsel, I'll go back to the four possibilities. Remember the four possibilities?
Yes, Your Honor.
About parentage of foundling?
Yes, Your Honor.
Three of which point to natural-born citizenship.
Parents, both Filipinos.
Yeah, number one, again.
Father or
Parents,
mother?
both Filipinos, citizen.
Yes, Your Honor.
Father Filipino, mother alien citizen. Mother Filipino, father alien citizen. 3, both mother and father aliens, not natural born, right?
The big hurdle is to pinpoint,
Yes.
not to speculate. A
No, no,
decision cannot engage in speculation, Your Honor.
I will go to that, counsel. Now, again, I will point to you section 4 of Rule 128. Evidence must have a relation to the fact in issue. The fact in issue is parentage. As to induce a belief as to its existence or non-existence. So, who are the parents? The evidence presented on record with you, with the Comelec, you have a duty to determine whether it induces a belief in you or in the commission as to the existence or non-existence of the matter in issue, which is parentage. Now, secondly, section 4, the second sentence. And also, this evidence, and I appreciate that the evidence of record is now closed. Whatever evidence, you have also an obligation to consider whether, in the words of the rules of court, it tends only in any reasonable degree to establish the probability or improbability of the fact in issue. So, the threshold is, you've heard the evidence, there are 4 possibilities. You have the evidence. The rules of court require you to make a decision. Do the possibilities, and there are 4 of them, induce in you a belief that Petitioner Poe is a foundling, or Petitioner Poe as a foundling is a citizen or not? Now, secondly, again, I go back to the 4 possibilities. The rules of court, to my mind, and that's why I keep coming back, and this is a matter of due process. You are, in my view, from where I stand, required by due process of law to arrive at what I call a factual finding, given the possibilities. And the rules of court doesn't talk about the possibilities. Given 4 possibilities, given what Poe has introduced by evidence as to where Haro is, airport, physical appearance, which you now have said is admitted, your legal obligation, not just as a rule of court, but as a matter of due process of law, is to arrive at a conclusion of the probability or improbability of parentage. And I stress, there are 4 possibilities. The rules of court doesn't talk of possibilities. It says evidence. And the evidence shows, and our logic shows, there are 4 possibilities. I say to you, your due process obligation to Ms. Poe is to arrive at a conclusion, or is it more probable than not, given the possibilities that her parents, any of the three, father plus mother, father or mother, are citizens? Or is it more probable than not, in your view, having seen the evidence, that no, it is more probable that both mother and father are aliens? And that really bothers me, counsel, because I think, and unless in your memorandum you can argue to me, you may, the Comelec may have crossed a line. You may have deprived petitioner Poe of her due process right to have the issue of fact, the matter of fact, the triable question of fact, as you put it, of whether or not her parents are Filipino.
May I respond, Your Honor?
Yes, counsel.
The rules of court require that the court or quasi-judicial body consider the evidence presented, which may tend to establish the probability or improbability of the fact in issue. Certainly, it does not require that speculation be the basis of a decision. Your Honor, please, even in civil cases where preponderance of evidence is required to arrive at a result, the preponderance is not necessarily with the greater number of witnesses. Assuming, for the sake of argument, that the deciding body, in this case Comelec, will consider as more probable the three combinations mentioned in your example or presentation, Your Honor, that could not justify a decision that Senator Poe is natural-born Filipino citizen, because that would be engaging purely in speculation without factual support. Because in Ang Tibay versus CIR, which is still good law and which has laid down the requirements of due process in administrative proceedings, it is mandated, among others, aside from the right to a hearing, the right to appear before an impartial tribunal, and the right to present evidence before the administrative body, it is a must that the tribunal must consider only the evidence that has been presented and no other. There is no evidence on record, Your Honor, that the probability was both parents Filipino, or mother Filipino, or father Filipino. With all due respect, that is pure speculation, and it could be struck down struck down by the Honorable Supreme Court for precisely violating also the due process right of the petitioners. They are also entitled to due process because essentially, Your Honor, as held in Baitan, with Justice Carpio as the ponente, due process, the essence is simply the right to a hearing and the right to observe fair play. We did that in these cases, Your Honor. The writing style may be different from the learned justices of the Supreme Court, but the assailed resolutions state the facts upon which the conclusions of law have been based. We may not be able to approximate the writing prowess of many justices here, and I have the greatest respect for many of you. Your Honor, I always find it pleasurable reading your decisions. But that is neither here nor there. I will respectfully insist, Your Honor, that we observe due process. I will have to deny it, Your Honor, that there was no due process in this case.
Can I go
With due respect, Your Honor.
And can I go to my next question, counsel? Now, you really have to help me out here.
Yes, Your Honor.
Because as a member of the court, I am a judge. And unlike most of my colleagues, I never had experience as a trial judge. And that is why I'm just using the rules of court. What I'm trying to convey to you is that whatever evidence of record is already of record, right? So I will have to decide based on the record. As you have said, both sides have said Petitioner Poe is a foundling, right?
Yes, Your Honor.
And to this afternoon, you have stipulated that all the other averments of Petitioner Poe, where is Haro International Airport, you also stipulate.
I do not stipulate, Your Honor, with all due respect.
Oh, I thought
The findings of facts were as follows.
No, I'm not yet on findings of fact.
By the parties, they stipulated, Your Honor.
Can I finish my question, Counsel?
Sorry, Your Honor.
My point is, the Petitioner Poe, in their verified answer, tendered, I thought you had said triable issues.
Yes.
And then and can I finish? And
Yes,
then
sir.
they laid out certain facts, like where Haro is. From there, they argue from where Haro is.
Admitted by the other side.
I have no question. Can you please let me finish? They have many allegations of fact. Where Haro is, at the time, there was no international airport. Up to now, there is no international airport. The physical features, they are asserting those as facts. Okay. The evidence for the physical features, height, color of hair, is of record. It's the passport. Okay. Now, I don't want to take a view first on whether on the others they have evidence. That's why I thought you had stipulated, but now you're saying you're not stipulated. But what I'm saying is...
I am not stipulating.
Yes, you're
Your
not
Honor.
stipulating, and I will bear that in mind. But what they have said as allegations of fact, they draw arguments like if foundlings are left because of poverty, it stands to reason, their argument is, from that fact that Haro, Iloilo, is predominantly Catholic, predominantly Filipino. From that fact, they argue that therefore, more probable than not, the question of fact should be decided in their favor. I have no question yet. And so, again, and cover this in your memorandum. Now, I am a judge.
Yes,
There is only so much evidence of record. We cannot change that. But I have to decide this case on the question of foundling. So, the possibilities are many. They are not speculative. Well, to the extent that a possibility is is speculative. But having heard all the possibilities from both sides, as a judge, I am bound still to decide. And I cannot say I will not decide because the evidence is not sufficient. I have to make up my mind which side did not have sufficient evidence. Therefore, I take issue with your saying that you cannot decide. You have enough to decide. But unlike the set made a finding of fact. It's more probable than not, they're saying that Poe is a Filipino, based on essentially the same evidence, if I may, that was presented before them. That's why I keep going back that it seems to me your ruling is founded because she's a foundling, ergo, under your reading of the Constitution, she is not natural born unless at some point in time, but now is not the time, you or she will have DNA evidence. Now, that bothers me because I will have to decide And as I said, I have never been a judge in my life. But from my reading of the rules of court, that is the obligation of the judge. As a matter of due process, and I agree with you, that is the meaning of the constitutional provision that decisions have to state clearly and distinctly the facts and the law on which it is based.
Can
So
I
I
respond,
would
Your
wish
Honor?
you to cover that in your memorandum.
Yes,
But if
Your
you
Honor.
want to say something,
Yes, Your Honor.
go ahead.
With all due respect to the Honorable Justice, I would beg him not to be bothered by this kind of, by this interpretation that the Honorable Justice has been led into, because I respectfully remind Your Honor that the only critical matter here is to determine whether there has been a false material representation in the COC of candidate Poe. Kindly consider, Your Honor, that Section 78 is summary, albeit adjudicatory also in character. And kindly consider, Your Honor, and this we will emphasize in our memorandum, that the petitioner, through Attorney George Garcia, who is here present, categorically stated during our hearing before the Comelec that this is a very simple case. They will submit the case on the basis of international law presumptions about foundling citizenship being natural born. And they did not request Comelec for extensive or adversarial hearings, and we were not bound to do that because no less than the Supreme Court has sustained the view that Section 78 is summary. I'm not saying that it can pass the Supreme Court scrutiny even without evidence. The assailed resolutions and the records of the cases will speak for themselves, Your Honor. As I said earlier, maybe it does not come to par with the writing prowess of our esteemed justices like the Honorable Chief Justice, for instance. But nonetheless, it is there. The facts are there. We observed due process, Your Honor, and kindly judge us on whether or not we committed grave abuse of discretion. In Sabili, by the way, I would hasten to add, the Honorable Chief Justice categorized the threshold of grave abuse of discretion as when the evaluation and appreciation of the evidence by the Comelec has become, quote, unquote, grossly unreasonable as to convert an error of law into one of jurisdiction. It's a very high bar to tackle or to hurdle on the part of the petitioner. Grossly unreasonable. That is the standard set in Sabili, Your Honor. And the Commission is respectfully invoking that. Together with the Rule 64, as well as in jurisprudence, that findings of facts of the Comelec, when supported by substantial evidence, are final and non-reviewable, not even by the Honorable Supreme Court. So that is our submission, Your Honor.
Will yield, provided after the line of questioning, can I ask again so I can rest also?
Good afternoon,
If
Your Honor.
the petitioner Poe wrote in her certificate of candidacy that she is a foundling, could there have been a decision, could there have been a situation like this one we are having?
Still the same, Your Honor.
So,
Because she would not be eligible, Your Honor.
So you will have to make a finding that a foundling is not a natural-born citizen.
There would have been, it would be to presume that there would have been also a complaint or a petition, and we would have decided it similarly. Had there been an open admission right in the COC
Yes, in the
that she is
COC.
a foundling,
That she
we
is a
would not have
foundling.
been left with any other choice, Your Honor.
Except to find that she was guilty of false representation?
Yes, Your Honor, in Tagulino, penned by Justice Perlas Bernabe,
She said
there is no need for deliberate intent or attempt.
There was no intention. She said, I am a foundling, and she stated in her certificate of candidacy. Can there be a finding of false representation?
Yes, Your Honor,
Why?
because it is a statement of a material matter that is false.
She said she's a foundling.
Your
She
Honor,
was not saying she's a Filipino, natural-born Filipino.
she is a foundling, Your Honor, please. But she has decided to put under oath that she is running for president, and the COC, which makes the status of a candidate, the COC is required to say, I hereby seek the office that I wish to be elected to, and that I am eligible for the office.
Yes,
So that is the very meat of the COC. You represent yourself to be eligible.
yes.
You represent yourself to be eligible, and yet you say, I am 35 years of age.
Yes.
I want to run for president of the Philippines.
And I am a foundling.
I'm just giving another example, Your Honor. So,
Okay.
if there is a statement in a COC that she is in fact a foundling,
Yes.
and despite that open knowledge, personal knowledge, she will file a COC for president, that is a false material representation.
How can you say this has an open knowledge? When she's saying, I'm a foundling, I'm running for president, and I represent myself as a qualified candidate.
Your Honor, please, this is why we have our mandate under Section 78. There is now an admission that she is a foundling. What does that mean?
What will be your ground if you say, I will cancel your certificate of candidacy in such a situation?
False material representation, because
Okay.
the Constitution excludes foundlings from being natural born.
That is your conclusion. And that's what I'm saying. How
It's
can-
not a conclusion, Your Honor. It is what the Constitution says.
And you say she ought to know that that is what the Constitution says, and that she should not have filed their certificate for candidacy because she knows that she is just a foundling, and that a foundling is not a citizen. Is that your position?
Your Honor, please, the COC in a Section 78 situation
Yes.
necessarily involves eligibility or qualifications requirement.
Yes.
And when you state a material matter that is false, that is a ground for cancellation.
Look what I'm asking you, Mr. Counsel. She says that I am a foundling. You
Yes.
said you will also nevertheless cancel her certificate of candidacy.
Yes.
And your ground will be
False.
that, there was material false representation there. And your basis would be that because she is not a natural-born citizen. In other words, you still will have to make that finding.
Yes, Your Honor, because the Constitution requires that to be eligible for president, you must be natural born.
Okay.
And when you say, I am a foundling
Okay.
and I am running for president, you are making a false material
Correct. And therefore,
representation.
I go now to the case. When Poe stated in her petition that she's a foundling, her fate is sealed. There can be no other conclusion except that her certificate of candidacy should be cancelled.
Yes, Your
No
Honor.
argument, no further argument.
Yes,
she
Your
said
Honor.
she's a foundling. No more argument. You made a false representation. You are not qualified. Therefore, your certificate of candidacy should be cancelled. Is that it?
Yes, Your Honor.
Okay.
Thank you, Your Honor.
We will go back to Justice Ardeleza after Justice Carpio and Justice De Castro are able to ask some more questions.
Yes, Your Honor.
Just clarificatory questions, Counsel. You've read already Ellis versus Republic of the Philippines,
I beg your pardon, Your Honor.
the Ellis case. Have you read
Ellis?
it? Yeah.
Yes, Your Honor.
It's a 1963 case.
Yes, Your Honor. Penned by my administrative law professor, Chief Justice Concepcion.
Okay, so did the fallo or dispositive portion of this case mention directly or indirectly, or rule directly or indirectly, that foundlings found in the Philippines are presumed to be natural-born citizens.
No, Your Honor, it did not because that was not the issue.
Oh.
The issue in the case was simply whether or not resident aliens can adopt under Article 335 of the Civil Code, Your Honor.
So, did this case ever discuss directly or indirectly that foundlings found in the Philippines are presumed to be natural-born? It did not even discuss it.
No, it did not.
So
It's
it
a
was
decision of 2 pages. It did not, Your Honor.
So, it's not in the dispositive portion. It's not an issue raised. It was not even discussed, correct?
That is correct. And the word
And-
foundling was not even mentioned, Your Honor.
The word foundling was not even mentioned. And the child involved here is not a foundling, correct?
Yes, Your Honor.
Okay. Let's go to the other case. Duncan.
I
You've
have
it
read that also, Your Honor.
Okay. Did the FALIO or dispositive portion of this case rule that foundlings found in the Philippines are presumed to be natural-born citizens?
No, Your Honor, because the issue in the case is the proper person to give consent to an adoption.
So this was an adoption case.
Yes, Your Honor.
So the dispositive portion did not rule that foundlings found in the Philippines are presumed to be natural-born. It was not even an issue, correct?
That is correct, Your
And
Honor.
it was not even discussed, correct?
It was not even discussed, Your Honor, and the word foundling was not even mentioned by Justice Isguera, who penned the decision.
yeah, the child involved here is not a foundling, correct?
Not, because the parent is known, entrusted only to Attorney Corazon de Leon Velasquez, Your
Okay.
Honor.
That is all, Counsel. Thank you.
Justice De Castro, let's look at the current state of the Constitution and the law. Will the Comelec and this court be justified in ruling in the case of all foundlings? Remember, whatever we say here or whatever you say in your decision will be applied, will be a precedent to future cases involving foundling.
Under
Now,
stare decisis, Your
Yes,
Honor.
will the Comelec and the Supreme Court be justified in ruling that even if the biological parents of a foundling are not established, are not found, then you can say that a foundling is a natural-born citizen because he or she is 5 feet 2 inches in height, that the foundling has brown or black eyes, that the child has black hair, that his or her complexion is morena.
That
Will you
cannot-
be able to make that decision?
No, Your Honor, that will violate the Constitution for sure.
You do not have any criteria to rely on in deciding that a foundling is a child of a Filipino citizen.
Yes, Your Honor, we only have to rely on the Constitution, Your Honor.
So in your case, if there is no law or there is no provision of a constitution establishing the criteria by which you will establish the citizenship or the natural-born citizenship is of a foundling, then you will have no justification at all. If there's no criteria laid down by law or by the Constitution to say that a foundling is a natural-born citizen,
We have justification, and there is a criterion, or there are criteria, being that a foundling, the fact of the matter is that a foundling has no known biological parents. Tie that up, Your Honor, with jus sanguinis, and tie that up with Section 2 of Article 7, that only natural-born can become our president. So the conclusion becomes inevitable. The inference can be drawn from those facts that a foundling, not being natural-born, is not qualified to be president.
so you're saying that you will not be justified in deciding that a foundling is a natural-born citizen because of her physical features.
Definitely not, Your Honor, because there are so many Filipino babies now with blue eyes, gray eyes, or even other kinds of mestiza features, Your Honor. We are a mixed race, Your Honor.
Going to the issue of burden of proof or burden of evidence, since the petitioner here is asserting that she is a natural-born citizen, and based on the allegations before the Comelec, she was citing her physical features. Now, did she present any evidence to show that no child of an alien has brown or black hair?
No,
That
Your
no
Honor.
child of an alien is 5'2" in height?
No such evidence, Your Honor.
That no child of an alien has a brown complexion?
There is no evidence to that effect, Your Honor.
So would you say that the burden of proof, in order that the possibilities can be established, there must be empirical basis
Yeah.
to determine whether or not a person or a foundling is the biological child of a Filipino citizen?
Yes, Your Honor, that was their burden, because the rule on burden of proof, if I may say so, Your Honor, is not only with the plaintiff, it can also be with the defendant if he sets up affirmative defenses. Because burden of proof is simply the duty of a party to present evidence to establish facts, to present evidence necessary to establish facts. To present evidence showing facts that will establish his claim or defense. That is how the rules of court is worded. So burden of proof is also on the part of the defendant. And they set up the affirmative defense of foundling being natural born. They did not present any evidence on that matter, Your Honor.
I just want you to study an American constitutional expert article was cited, but take into account that the U.S. followed the common law system, which they borrowed from England, from where the earliest pilgrim to the U.S. came from. So the main system of law in the U.S. is common law.
Yes, Your Honor.
And their constitution was ratified in 1788.
Yes, Your Honor.
Our constitution is very new, and we have been under Spain for a long, long time, and we follow the civil law system, which is now called from the Roman law. So although we have a sprinkling of common law principles, I think you should take that into account when you study the teachings or the article written by American writers.
Yes, Your Honor.
Because we have different system of law. They follow the common law system. And
Yes, Your Honor.
many of their decision are court laid down rules which are not based on law.
Yes, Your Honor.
Okay.
Justice Bersamin, Justice Reyes, Justice Ardilesa, can you yield to our two colleagues first? Justice Bersamin.
Counsel,
Good afternoon, Justice.
Yes, may I go into this residency qualification?
Yes, Your Honor.
Do we admit that Senator Poe, before she abandoned her allegiance to the United States, was a dual citizen?
Yes, Your Honor.
We admit that.
We admit that, Your Honor. That
Now,
is shown by the record. Your
Yes. Is the position of the Comelec like this, that a dual citizen can only have one domicile? Or
Yes, definitely, because that is the ruling in jurisprudence. A person can have only one domicile at
All
a
right.
time.
Who chooses that domicile for her? At that time when he or she was a dual citizen?
In the context of marriage, it's a joint decision of husband and wife, Your Honor.
Okay, we have a law, a provision in the Civil Code, reiterated in the Family Code,
Yes.
that it is the husband who usually defines the situs of the domicile,
Yes, Your Honor.
except if the wife chooses to have her own domicile for purposes of conducting her own profession or business.
Yes, Your Honor.
That's under the Women in Nation Building Act.
Yes, Your Honor.
Okay. May I assume, for purposes of these queries, that Senator Poe looks back after having filed this COC looks back to the time when she was a dual citizen. In her view, she had a domicile in the Philippines. Would you not accept that?
Well, our ruling, Your Honor, was to the effect that the earliest she could have reestablished Philippine domicile was when she repatriated on July 18, 2006, coupled with actual bodily presence. And we categorize that act as evincing also animus manendi and animus non revertendi, because we now took into account her claims of sending over her belongings and the other evidence that she mentioned, Your Honor.
No.
But prior to that, she was still a U.S. resident.
Okay. Is domicile subjective or objective?
Well, I would say it may be both, Your Honor.
So if it is both, no one can tell a lie about the domicile she misrepresents or she represents.
Yes, Your Honor.
So,
it is objective if the facts are such that the court is left with no other choice but to ascribe a specific date, arbitrarily, if you will, although that is not the correct word, for reckoning the reestablishment of residence. Like in this case, July 18, 2006, when she repatriated, consistent with Coquilla, because before repatriation, she was just here on Balikbayan free visa-free Balikbayan program, Your Honor.
all right. Domicile is oftentimes subjective, but when it is objective, it should depend on certain circumstances like animus manendi, animus non revertendi, etc.
Yes, sir.
Non revertendi in this case, if it is equally subjective and objective, will not figure into the equation. Will you agree?
I beg your pardon again, Your Honor.
Okay. You just admitted now that domicile in the case of a dual citizen may be subjective and objective.
Yes, Your Honor.
So, it is possible that this particular guy, let's not call her Senator Poe yet, had two domiciles when she was a dual citizen. I'm using the female gender. Had two domiciles when she was yet a dual citizen under our laws, under the laws of the United States as well.
Yes, Your Honor. If still dual citizen, she can have residence in either country because she has two citizenships.
She has many links
Yes, Your
to
Honor.
the Philippines.
Yes, I get the question now, Your Honor. Yes, Your Honor.
So will you not count that when you would have a person like Senator Poe file a COC for the office of the presidency?
We will not count that, Your Honor.
Why not?
That will not be counted because re-establishment of domicile, while different from citizenship, should evince the three elements, Your
Yes,
Honor.
but citizenship and domicile or residency, they're two different.
Yes, Your Honor.
They come under different standards.
Yes.
Now, the only purpose why we would require residency, if you will agree with me, is that a person who offers herself to the constituency in the Philippines must be familiar with the conditions of the constituents, and it is for that purpose that we require 10 years for the presidency. Is that correct?
Yeah, plus the hopes and aspirations of the people. That is correct.
Yes.
That is jurisprudence, Your Honor.
Aspirations of the people, etc.
Yes, Your Honor.
If she was for many years a Filipino citizen, at the same time she was a U.S. citizen, she was for many years maintaining a home here. The mother, the father they were both here, but she actually lived in the United States. That did not interrupt at all her domicile in the Philippines. May we not say that?
Well, Your Honor, please. The fact of the matter is that Philippine residence for purposes of the election law is similar to domicile.
Yes.
And she has to show
The term we use is synonymous.
synonymous
It is
with
stronger
domicile.
than similar.
Yes, Your Honor. And so she has to show that she has re-established domicile. Assuming she had another domicile, assuming that that is legally possible, because the jurisprudence from the court states that a person can only have one domicile at a time. Assuming she had that, the totality of the circumstances show that she was still a U.S. resident and that her legal domicile was not in the Philippines, notwithstanding the fact that she was already here because there was yet no animus manendi, merely balikbayan visitor, temporary in character, and no animus non revertendi because the residence in the U.S. was still there. The husband was still there.
All right. Animus, what is this? Animus, what is this?
The spirit, Your Honor.
Okay, you can only prove that by manifestations of external or overt acts.
Correct, Your Honor.
All
Overt
right.
acts.
When you, as the resident in the United States, a dual citizen before, sell your property there, bring your children back to the Philippines, have your husband, who is a domicile there because of the citizenship, back to the Philippines. Is that not a confirmation of an animus non revertendi?
I will call it seemingly, but it is not in accord with jurisprudence.
Why seemingly? I do not
because-
like that term
I
you
withdraw
use.
the word seemingly. It is not synonymous with re-establishment of domicile because following Coquilla, domicile is re-established by waiver of non-resident status. You cannot just come over to the Philippines, enter the Philippines as a temporary visitor on a visa-free balikbayan privilege or program and stay here, perform acts that any other resident alien could do, especially that there is evidence that they have other properties there also.
But they had also properties here.
I beg your pardon, Your
They
Honor.
had also properties here.
Yes, buying properties in the Philippines is not necessarily proof of intent to reside in the Philippines.
Yeah, we have
so
settled
many,
that.
We have so many Filipinos.
I am only about to ask you what would be necessary as circumstantial evidence of animus, because you cannot prove animus directly.
Yes, Your Honor. The animus was amply proven when, as I said in the previous hearing, she finally crossed the Rubicon. The point of no return was reached. She passed that point of no return when she firmly decided to reacquire her Philippine citizenship.
Well, it was...
And not only that, bodily presence and registration as a voter. The animus manendi became very, very evident, Your Honor.
Okay, so we are agreed that a dual citizen may have a residence or domicile here for purposes of our election law.
Well, a dual citizen, that interpretation, Your Honor, might be correct, if I may say so, because a dual citizen is not yet a candidate. When he seeks public office,
Yes.
as opined by Justice Peralta, the dual citizen must now renounce. And at that time,
A
he can
citizen,
qualify.
a dual citizen cannot run for public office, cannot
Yes, sir.
occupy a public office.
Yes, Your Honor.
But is that necessarily the only time you can define domicile for purposes of complying with that requirement?
Before renunciation or before repatriation, legal
That's for running for public office.
Yes, Your Honor. Before repatriation, a person cannot run. Before reacquisition of Philippine
No,
citizenship.
we are talking about a dual citizen. You don't need to repatriate a dual citizen, don't you?
Well, if he seeks public office, Your Honor.
Yeah, I know that. But that public office seeking requires only a renunciation.
Yes, Your Honor.
But as far as citizenship is concerned, you can be a dual citizen all the time. Until you make a renunciation, the renunciation can come one day before or on the day itself of the filing of the certificate of candidacy, is it not?
As held in Pribaldo, Your Honor.
Well, we do not mind
Citizenship.
which cases
Yes,
are
Your-
these, but that is now the current
Yes,
doctrine.
Your Honor.
So, the objective and subjective thing that we were agreed upon a while ago allows a person like Senator Poe to have two domiciles.
Well, Philippine jurisprudence may not really allow that, Your Honor, because of the rule that a person can only have one domicile at a time.
Well, that
She may have had a residence here, but not legal domicile.
no, it's like this, attorney. I think I remember that we are strict about one domicile if that person has never acquired another citizenship. Dito sa Pilipinas yan, kung siyan tumatakbo, kailangan he has to comply with the domicile thing in one specific place at
Yes,
any
Your Honor.
given time. Like for example, myself, I work here in Manila. I have my own house here, residence here, but I am registered voter in another place, far away from this metropolis. Anytime I want to go home to run, I can do that all the time because I am supposed to be domiciled there.
Yes, Your Honor. In your case, Your Honor, with due respect, your animus revertendi to Abra.
Why do you know it is Abra?
Because I used to
You see?
I used to appear before you in RTC Quezon City, Your Honor.
Okay, I have no further questions, Chief.
Justice Reyes.
Your Honor, if you will just allow me, it's not that I am fond of quoting, but let me just end the short manifestations between this council and Your Honor by citing what you said in your concurring opinion in Dominador Halosos. The ineligible candidate thereby makes a mockery of the ballot and renders the electoral exercise into an expensive joke. In our memorandum, we will highlight that, Your Honor, in regarding the residency requirement that has to be met.
Is that not argumentum ad hominem?
It may be. Pardon me, Your Honor.
Justice Reyes.
Just good afternoon, Commissioner Lim.
Good afternoon, Justice.
Few clarificatory questions. Section 2, Article 7 of the Constitution provides that no person may be elected as president unless, among others, that who are a natural-born citizen and the 10 years residency requirement.
Yes, Your Honor.
Are the requirements of natural-born citizenship and 10 years residency requirements separate qualification so that a candidate's period of residence in the Philippines during which he is a foreigner may be included in the counting of the years of his residency in the Philippines for purposes of election? Or
Yes,
stated
Your-
otherwise, is it required that the candidate for president to be already a natural-born citizen, a Filipino citizen, at the time he has been a resident of the Philippines for 10 years?
Your Honor, because there can be waiver of non-resident status prior to reacquisition of Philippine citizenship, it would seem, and it is, I think, the result, that an alien, when he becomes a resident alien, his period of residence can be tacked to the actual 10-year residency requirement. And as regards citizenship, as held in Pribaldo even, on the day of assumption of office, you can be a citizen, although that is an isolated holding. So, citizenship is different from residence, and to answer your question, Your Honor,
So it's separate and distinct, of course.
separate.
No question
And
about that.
her residence, her period of residence as a resident alien in the Philippines could qualify. That's outside our resolutions, but I'm just trying to answer as best as I can your question, Your Honor.
All right, I would go to the second point. Section 1, Article 4 of the 1935 Constitution does not explicitly exclude nor include the foundlings in the enumeration of those who are considered citizens of the Philippines. Of course, you will agree with me on that question.
Is that the section that says those who are naturalized in accordance with law?
There is no express terms whether a foundling is a citizen or not.
Yes, Your Honor. That is correct, Your Honor.
So the issue of whether a foundling found in the Philippines is considered a citizen of the Philippines or a natural-born Filipino has not been squarely raised for resolution before this court in any case until now.
Not that I am aware of, Your Honor. I am not aware of any case that has reached the court involving this kind of issue.
This is the first time that that issue on being a founding regarding the presidential regarding the presidency is questions before the court before this court.
I believe so, Your Honor. I believe so.
All right. We all know for a fact that the set prior to the promulgation of the Comelec resolutions assailed herein, ruling on whether Grace Poe is a natural-born Filipino, had ruled that foundings found in the Philippines are considered natural-born Filipinos. That's the ruling of the SET. As far as the senatorial position of Senator Poe is concerned.
Yes, that's a majority ruling, Your Honor.
So, Mr. Counsel, would it be fair to say that then that the issue of whether foundings found in the Philippines are considered natural-born Filipinos is a difficult question of law, such that when Senator Poe indicated in her COC that she is a natural-born Filipino citizen, it was done in good faith.
With all due respect, I respectfully disagree, Your Honor, because in Makiling, and I will mention it again, the novelty of the issue on the effect of the use of a U.S. passport after renunciation of U.S. citizenship did not prompt or motivate the court to take a lenient or benevolent attitude towards Arnado. The Honorable Court, in that ponencia of the Honorable Chief Justice, cancelled his COC. Notwithstanding the novelty of the issue, notwithstanding the fact that the use of that U.S. passport was only an isolated act, I think it was just once, and notwithstanding the fact that the Honorable Court, as suggested by Justice Brion, could have required Arnado to execute a new oath of renunciation and submit it to the court. But the court chose to strictly enforce the Constitution, which ought to be the case, if I may say so, Your Honor.
But Mr. Commissioner Lim, in this particular instance, especially the set, there was a declaration on the part of the majority of the members that Senator Poe is a natural-born citizen. So when she placed in her application that she is a Filipino, natural-born Filipino, she did that in good faith.
It might have been, that could be plausible if the filing of the COC came after the set ruling. But the fact is that the filing of the COC came ahead. And not only that, more importantly, Your Honor, whether ahead or after, the provision of the Constitution is very clear about foundlings. And it is undeniable that the set ruling still pens before the Honorable Court. So it's not final. It is not yet part of the law of the land. Because with due respect to the three justices of the set, they are just three. The Honorable Supreme Court is 15. And the Supreme Court has judicial review power over the set, although the set is an independent electoral tribunal. And I would say, Your Honor, and respectfully submit, that the ruling of the SET is not part of the law of the land, with all due respect. It's only the ruling of the Supreme Court of the Philippines that is part of the law of the land. So we in the Comelec did not feel bound by the SET ruling, with all due respect to the SET, Your Honor.
But we know for a fact that Senator Poe is not a lawyer, so she's not familiar with the intricacies of the laws, whether such decision is final or not.
If I may respectfully point out, Your Honor, she may not be a lawyer, but she is a political science graduate. Not only that, she has a band of lawyers, a staff that could, legal staff that could have advised her, because she is Senator of the Republic. This is not, I hope it's not taken as a comment that will unduly put the good senator on the defensive, but we are talking of facts, Your Honor. The filling up of a COC, which is a legal document, must have been with the assistance of counsels. And she signed it, and it's under oath. And a notarial document is prima facie evidence of the facts therein stated, Your Honor.
I'll just go to one more clarificatory question. This is regarding the apparent conflict between the provisions of the Constitution, the rules of court, and vis-a-vis a certain Comelec resolution.
Yes, Your Honor.
Because reality and factually wise, petitioner Poe, in several surveys, appears to be very capable of getting the electorate votes. In fact, at this point, if we will base our position on newspapers, she appears to be number one in the survey.
Yes.
I'm just wondering if I remember distinctly, the decision of the Comelec disqualifying Poe as presidential candidate was issued on December 23, 2015.
Yes, Your Honor.
And it was personally furnished to her on that specific date.
Yes, Your Honor.
And mind you, under Section 8, Rule 23 of the Comelec Rules of Procedure, as amended by Resolution number 9523, provides that the rulings of the Comelec and Bank is deemed final and executory if no restraining order is issued by this court within 5 days from the receipt of the decision or resolution. And as I have said before, the decision was issued December 23, 2015. It was served to Poe on the same day. And mind you, that was December 23. So this is a Christmas season. So if we will consider that, had not for the injunctions issued by the court, Poe might not be able to file the timely petition before this court because of the 5-day period requirement to appeal the decision of the Comelec and Bank. Am I right to say that, to state that?
May I comment, Your Honor?
Yes, Mr. Counsel.
There is such a rule. I confirm, Your Honor, that after the lapse of 5 days, the decision of the Comelec becomes final and executory, principally because under the same Rule 64, the appeal by way of special civil action for certiorari to the Supreme Court within 30 days does not stay the finality of the judgment of the Comelec. And since this appeal is not a mode of appeal like Rule 45, which necessarily states the judgment of the court ako or of the lower court, this is simply a mode of review provided for whereby an aggrieved party may go up to the Supreme Court within that 30-day period. But always, Your Honor, it should be borne in mind that the decision, unless restrained by the court, is already final. Now, why 5 days to obtain a TRO from the Supreme Court? Because of the very strict timelines that we have to observe as election law enforcer and administrator. Even as we speak, Your Honor, we seem to be in a bind regarding certain timelines, not because of this case, but because of other constraints. So Comelec has to operate within strict timelines, also strict budget, and despite the holidays, we do our job, if I may say so. Now, why was it released? December 23, when December 24, 25, 26, 27 were holidays. It was because the two assailed resolutions became ready for release and promulgation on December 23. The fact that the following days were holidays was purely coincidental. Now, why still release it, knowing there was this holiday? Because we had the firm assurance, and we cannot cite any reason to doubt it, we had the firm assurance from the Honorable Chief Justice that the Supreme Court was prepared for any exigency. And true to her word, on December 28, the two petitions were issued TROs by the court. And, Your Honor, I would like to state personally on my oath, I participated in these deliberations. There was no intention to make life difficult for them or to try to outwit them, make the decision final and then say, you can no longer have recourse to the Supreme Court. We knew and we anticipated and we knew for a fact that because the court would not have had the time to scrutinize voluminous petitions in a single day, despite all the staff here present, that there would be a TRO. We knew there would be a TRO because the Supreme Court would be expected to act to preserve the rights of both parties. Not because we were saying that we could telegraph what the court would do, no. But we were of the belief that the court, being given only effectively 1 day, will preserve the status quo. Because the Chief Justice announced that the Supreme Court, despite the Christmas holidays, was ready, that there would be justices in the court, and that the Madam Chief Justice will be in Manila. And she did issue this TRO, Your Honor. So, I just would like to dispel that misimpression. If I may interject something personal, Your Honor, I would not be a party to such acts of oppression on a party litigant. Everything here, Your Honor, is a matter of just doing our job and mandate. Nothing personal at all, Your Honor.
So it is your position, Mr. Counsel, that had not the Supreme Court issued the TRO and the petition was filed way above the 5 days period, still the Comelec will not oppose the petition to be filed by Poe before us, Mr. Counsel.
We did not discuss that possibility
I'm just,
of
just curious
implementing our decision already because there is no TRO from the court. We took things at a time. We did not tell ourselves in the en banc deliberation that if the Supreme Court will not issue a TRO, we will now delete her name from the ballot. There was no such thing, Your Honor. We were just even hoping that the court will preserve the status quo, as it did, as any court would do if presented with a case where a study still has to be made. The status quo will be preserved, and when the Chief Justice issued those TROs, we welcome them, Your Honor.
All right, thank you, Mr. Commissioner, for the enlightenment.
Thank you, Your Honor.
Justice Ordileza, Justice Leonel would just like to interject a little bit before we go back.
I yield, Chief.
Okay. Justice Leonel, please.
Just some brief questions, and probably you can cover this in your memoranda if you do not feel that you're ready to answer this directly.
Yes,
Are you
Your Honor.
familiar with Republic Act 6768?
Republic Act 6768, I may not have,
Yeah.
I may not recall the number, Your Honor.
Yes, this is the Balikbayan program.
Yes, Your Honor, yes.
In
I have read the law.
2004, as per the documents that were submitted to us, the petitioner came on a visa-free entry.
Yes, Your Honor, for 1 year.
Visa-free means no requirement for a visa, correct?
Yes, Your Honor.
And no requirement for a visa means that she was not under any requirement to apply for a non-resident visa. Is that correct?
Yes, but she could have.
And that she was not also required to apply for a resident visa, correct?
Yes, but she
And
could have,
within the
Your Honor.
1-year period of the Balikbayan program, is it prohibited to establish residency within that period?
Since explicitly the Balikbayan...
Yes, I would appreciate if this is covered in the memorandum
Yes,
of
Your
both
Honor.
parties, because I can probably predict your answer, but I need a few more authoritative sources on this. And the question is, given that there was an allowance for a visa-free entry for 1 year, is it prohibited under the law, that law, or any other law, that residency for purposes of election called domicile can be established? Okay, my next point is this. Two naturalized, let us say Pakistani, African, Asian, okay, father and mother, give birth to a daughter in the Philippines. Okay, naturalized Filipinos already. Can that daughter run for president?
No, Your Honor.
Again, a naturalized father, a naturalized mother, gives birth to a daughter. Can that daughter run?
I should not have answered spontaneously.
Yes.
Naturalized parents giving birth to a child, and they are already naturalized. They are natural born, Your
Yes,
Honor.
even though the ethnicity of the father, let us say, is Middle Eastern, the ethnicity of the mother is African,
Yes, Your Honor.
okay, they can run. A child found in Haro, Iloilo, with ethnic features that are Filipino, probably born of Filipino parents, because of the place of birth, she cannot run for president. That's your position, right?
Yes, Your Honor,
Okay.
because there is jus sanguinis, Your Honor.
Are you aware that we diverted from the U.S. Constitution sometime in 1935 with the passage of the 1935 Constitution on the concept, the constitutional concept of social justice? In other words, the U.S. Constitution did not mention the word social justice, but we did in 1935. Are you aware of that?
I have some little knowledge expressed in Kalalang versus Williams by
And
Justice Laurel.
several journal
Yes, Your
articles
Honor.
have gone through the origins of judicial review. One of it is authored by Ana Lea Fidelis Castañeda. Okay, and she points out this very clear difference with the U.S. Constitution. In 1935, we made sure that social justice was found in our Constitution. I would excuse you from not reading this article because it was found in the Ateneo Law Journal.
Yes, Your Honor.
But it is
Thank
a
you, Your
very,
Honor.
very interesting read and very detailed at that on the origins of the Constitution. Constitutionalized is the principle of social justice. 1987 Constitution went further. It constitutionalized the concept of human rights. Now, perhaps again in your memoranda, you could help us interpret the Constitution, because I think this was the point in the article of Lawrence Tribe. And as this was mentioned by Justice Francis a while ago, I had my staff print it out and read it through it very quickly. And it doesn't talk about the U.S. Constitution. It talks about the problem of constitutional interpretation when there are silences. And I think the idea is that we take the constitutional principles of the entire document, and part of it is social justice and human rights. If you do not agree, of course, you can always cover that in your memoranda. Okay, thank you, Counsel.
Thank you, Your Honor.
Justice Hardeleza.
Counsel,
Yes, Your Honor.
you have been on the podium for almost 3.5 hours.
It's all right. I can still manage, Your Honor.
Well, I had the benefit of some rest. I hope you have no issues. Sugar, you don't have sugar issues.
I beg your pardon, Your Honor.
You don't need to have sugar at this point in time.
No, Your Honor.
I just want you to to let you know that the bailiff per practice can give you whether classical cola or no sugar cola if you just need, or water will be fine.
Just water, Your Honor. Thank you, Your Honor.
Thank you. I'll try to speed up my questioning, and I think if we can keep to briefer answers, because I understand fully
Yes, Your
where you come from already on due process.
I'll do that, Your Honor.
Now, where can I go back again to foundling?
Yes,
And
Your
I
Honor.
promise, as I said at the start, my questions are only on foundlings. Now, I am not suggesting that you violated due process because the proceedings that you took were summary.
Yes.
I'm not suggesting that. I'm just saying that summary as it is, you have already whatever evidence is on record. So I'm not taking you to task for that. I am also again repeating that all the questions I've had so far that you've received from me do not talk about international law. So I am not again taking you to task about your about international law. Okay? I keep saying that this case has to be decided in accordance with the 1935 Philippine Constitution, and that we keep our focus on the two most important provisions, to my mind, due process and equal protection. I am not also sure that I agree with the argument of petitioner that there is a disputable presumption that foundlings are natural-born citizens. And I will ask the petitioner, Petitioner Poe, to please cover that in your memorandum, Counsel. That is why I agree with Justice Reyes that this is a case of first impression. That in fact, there is no decided case by this court which will guide us on this issue. And that's why I agree at this point, unless there is some argument in the memorandum, that it seems to me the Ellis and the Duncan cases are not definitive or are not controlling in this case of first impression. What I am focusing your mind is, I think you may have crossed the line by not, I go back to my thesis, by not deciding whether it's based on the evidence, whatever it is, the evidence adduced in a summary proceeding, I go back, my thesis is you may have violated the due process rights of the petitioner, Poe, by not deciding to tell us why all of the evidence, and I'm not saying I have made up my mind what is the evidence, you, I think, the Comelec may have crossed the line, and by not expressly, distinctly putting in your decision that the evidence did not induce a belief in you, or that more probable than not, and I'm just using the rules of court, not international law, that is my point, which I hope you will cover in your memorandum. Now, I'll give you a hypothetical, because again, it bothers me that your position now, which is, and your position, which is borrowed from one of the dissenting opinions in the set decision, seems to be that foundlings are, and I don't know, I don't want to put words into your mouth, foundlings are not natural born until they produce DNA evidence. Is that correct?
Well, not necessarily, Your Honor. We can say foundlings are not natural-born citizens, period. That is our decision. But for purposes of the hearing, however, because of the exchange of views, we saw the wisdom in the suggestion of Justice Carpio. But if you read our decisions, but I believe you have read and reread, but as it is clearly stated in our assailed resolutions, Your Honor, the finding was simply that being a foundling, there is no bloodline to a Filipino parent, parentage unknown, therefore not natural born, therefore not eligible, therefore material misrepresentation under Section 78. That was all. And we stand or fall by those findings, Your Honor.
I hear you loud and clear, Counsel. Now, again, please cover in your memorandum, because from where I sit, my take is that your reformulated statement today, citing the dissent in the set, is actually, in reality and in fact, and as a matter of fact, you are really positing a conclusive presumption that foundlings conclusively under the Constitution are not natural born. I'm saying again, that is my take. I will give you all the opportunity to argue against it. But that, from where I sit today, that is my take. And as I agonize over this case, I have to be candid to you that you have to convince me that it is otherwise. And you want to comment now?
Well, we understand where the good justice is coming from. The Comelec, in performing its mandate, limited itself to the issue of determining whether or not there has been false material representation. And the Commission concedes the correctness of the comment of the Honorable Justice that this would be a case of first impression before the court, but that will not prevent the court from considering the only yardstick that is applicable, and that to us is the Constitution, Your Honor.
I hear you loud and clear, Counsel. I think your argument, and I'm not saying I accept it, your argument definitely is not silent. You have a very clear argument from your point of view. Now, I'll give you again a line of questionings where I am so conflicted or so organized about these conclusive presumptions. I'll give you a hypothetical. Suppose the Philippine Congress passes or amends the family code and says that all unmarried fathers are unqualified to raise children. Therefore, in case of a child, custody is conclusively should be with the mother. Again, I repeat, the proposition is all unmarried fathers are unqualified to raise children. Is that constitutional or not?
Offhand, I will say that that has to be subjected to a thorough study, Your Honor. But if Your Honor wants an off-the-cuff reply from this representation, I can also volunteer.
Go ahead, counsel. Have your off-the-cuff reaction to my hypothetical.
That may be offensive to the Constitution, Your Honor. Equal protection of the law clause. There is supposed to be gender equality. Why discriminate against us, the fathers?
Now, I'll give you another hypothetical, counsel. Suppose the Philippine Congress passes a law saying that in the public school system, all public school teachers at whatever level, elementary, kindergarten, high school, or college, public school, beyond the fifth month of pregnancy, female public school teachers have to take a forced leave without pay because beyond the fifth month, they cannot discharge their duties as a public school teacher. Again, that's a hypothetical. What is your reaction to that?
Your Honor, please, if the problem would be modified somewhat to include that instead of without pay, there will be remuneration. It will not be constitutionally offensive for the reason that under our social justice provisions of the Constitution and the family provisions in the Constitution, it will just become an example of a law that takes into account the frailty of a woman's body and the need to protect her from undue stress of work from fifth month pregnancy upwards. But since in the example given, there is deprivation of wages, which could still have been earned up to, I think, I'm not a gynecologist, but I think a pregnant woman can still properly render work up to 7 months of pregnancy. So 7 or 8 months maybe. So deprive her of her pay during that 3 extra months. That will be unjust deprivation of property without due process of law. That's an off-the-cuff reply, Mr. Justice.
So you think it is offensive because the hypothetical may violate due process and equal protection?
Well, a case has to be decided case by case, Your Honor. These are important issues that Your Honor has raised. We will address them in our memorandum also, Your Honor.
Please do, counsel, and I am very pleased that your gut reactions are exactly the decisions made by the Supreme Court, no less, of the United States in the test cases of Stanley versus Illinois and Cleveland Board of Education versus Lafleur, Lafleur. Pardon me, I thought I had put in my notes the citations, but can you get the citations?
We'll get them from your office, Your Honor. Can we do that, Your Honor?
So, what I am sharing with you, counsel, is your gut reaction or your gut feel is constitutionally correct. Yes, indeed. It is offensive to the Constitution according to the Supreme Court, and these are actual cases. Both examples, unmarried fathers are unqualified. They say that's offensive to the Due Process Clause and to the Equal Protection Clause. The example of the public school teachers is an actual case in the Ohio Cleveland Board of Education. They tried to say beyond 5 months you take a forced leave. So I agree with you, and I would like you to check out these cases. And just even using your gut reaction, the U.S. Supreme Court in these cases held the conclusive presumption that unmarried fathers cannot rear a child, and the conclusive presumption that beyond the 5th month, a woman cannot perform her duties, as both conclusive presumptions which have no place in a constitution where you have due process of law and equal protection of the laws. Will you check it out and cover that in your memorandum?
Yes, Your Honor.
Now, of course, in the United States, and then in fact it cites 3 other cases, I think. And remember, a while ago, I mentioned to you that the reason conclusive presumptions are not favored as a matter of logic or as a matter of the law of evidence is that, and I quote, presumes a fact which is not necessarily or universally true. I will share with you now that that quote is from the 2 cases. So I did not make that up, and that's not just a matter of evidence. The reason you cannot have a conclusive presumption either way, you cannot have a conclusive presumption that a foundling is natural born is because it is not necessarily or universally true. As I tried to show to you, there are in fact 4 possibilities plus other evidence. The converse is also true. You cannot have also a conclusive presumption that a foundling is natural born. Not conclusive, because that is again not universally true. Even if there are 3 possibilities, you have the 4th, that both parents are alien. And that is why I want you to read very carefully these 2 cases. And that is why I from my reading of the petitions, the petitioner Poe is not claiming that there is a conclusive presumption that all foundlings are natural born. What petitioner Poe is asserting is there is a disputable presumption that a foundling is natural born and citing international law. Now, I stress, and please cover this in your memo, I do not necessarily agree with the theory of the petitioner, because when I look at the rules of court, I cannot find a disputable presumption that a foundling is considered disputably natural born. They are citing, I think, double Y, which is ordinary course of events. But that is different from asserting that there is a disputable presumption. Now, that is why I stayed clear of international law, and I am suggesting to you, and please cover it in your memo, I still go back to the agonizing problem. This is a case of first impression. I am a judge. I have to decide this based on our own rules. It seems to me there is no disputable presumption either way. It seems to me there is no conclusive presumption either way. That is why I agonize over this case, which you apparently in the Comelec did not. Under the rules of court, I have to decide as a judge whether whatever evidence you have now, however much or however spare and given in a summary proceeding, will induce a belief in me that petitioner Poe is natural born or not, and that all of the possibilities argued by the petitioner and all of the four possibilities, I, as a judge now, I am not talking of international law, and I'm saying I doubt very much that there is a disputable presumption. I still have to decide, is it more probable than not that petitioner Poe is a Filipino natural, or is it more probable than not that she is an alien? And that is something that I would like you to cover in your memo.
Can I make just one short reply, Your Honor? I respectfully submit that we are not dealing here with universal truths. We are dealing here only with one truth, and that is the truth laid down for us by our Constitution. I respectfully submit that the issues in this case are clear-cut, though somewhat complicated. They are simply presented. It is only whether or not a foundling is a natural-born citizen eligible to become our president vis-a-vis the mandate of the Comelec to determine material representation on that matter, which is false. I would respectfully submit, Your Honor, that universal truths, as although important, could be just vague sources of authorities to resolve this case. I would really respectfully request that the focus be on the Philippine Constitution, Your Honor.
Thank you, Counsel. And I thought that is what I'm trying to do, focus on the Philippine Constitution. Now, lest you will say that I am invoking American precedents, are you aware if there are decided decisions by this court which accept or have applied the principles about conclusive presumptions in a Philippine case?
Conclusive presumptions, Your Honor?
That conclusive presumptions are a no-no in constitutional law because it presumes a fact which is not necessarily or universally true.
It could be the opposite. It could be
My question
universally
is, are you aware, because this is a case of first impression, are you aware of Philippine decisions by this court, not American decisions, saying that conclusive presumptions are unconstitutional because they suffer from the vice of a violation of due process and equal protection?
What I am aware of is that case, for example, pointed out by the Honorable Chief Justice, where a married woman commits adultery, but the child is considered the child within the marriage.
apart from that case, is there any other case that you are aware of? And I can cut this short, counsel. Please check 2 cases, 2 en banc decisions of this court. GSIS versus Montes Claros 204. No, I'm sorry. Decided en banc. Unanimous 2004. 434 SCRA 441. That's the first case. The second case, DYCAICO, DYCAICO versus SSS. En banc, unanimous, decided 2005, 476 SCRA 538. In both cases, counsel, the court said, again, pointing to the American cases that I pointed to you, conclusive presumptions are a no-no in this jurisdiction because conclusive presumptions violate 1, due process, and 2, equal protection. Now, I will tell you the facts. They both involve, in one case, it's the SSS, in the other case, it's the GSIS. So what do you think is the case all about? It's about pension benefits. Okay. In the case of Montes Claros, the wife, the survivor, was disallowed pension benefits because she married, because under the SSS law, if you marry before 3 years from the death, it is considered a sham marriage. In the GSIS case, it's almost the same. Pension benefits. The pensioner who was a member of the GSIS had a wife. In fact, they had already a 24-year-old child. And all the while, she was receiving benefits. But unfortunately, she married, I think, and the husband died within 3 months. Now, in both cases, this court unanimously, 2004, 2005, en banc, held that the provision of the SSS law conclusively finding that if the marriage is done within 3 years, then it is a sham marriage. And in the case of the GSIS, that if the marriage is done before the pensioner dies, in both cases, this Supreme Court said they are unconstitutional. So they declared portions of the SSS and the GSIS law as unconstitutional for the vice of conclusive presumption. Again, based on due process and equal protection. And in respect of due process, the ground is because you are not giving the woman, the wife, an individualized hearing to prove that she is entitled. And then the court said, just like the American cases, you must give an individualized hearing. Now, I know in this case, you had a summary hearing. And that is why now, I think you go back to my question. You did have a summary hearing. But due process of law means that you have to consider the evidence. And again, I say to you, my reading is, while you said there was a summary hearing, you did not reverse the triable questions of fact. Unlike the SET, where they made a finding, in effect, my reading, again with all due respect, is that you just said, essentially, she is not natural born because this is the way we read the Constitution. And that is why you helped me out in your memorandum. My feeling is you are really setting up a conclusive presumption. Would you care to comment?
We will note that, Your Honor. We will note that. Our resolutions speak for themselves, of course. We conducted a hearing. It was summary. And the resolutions were based on the evidence presented, Your Honor. And we evaluated the totality of the evidence. The issues were simple enough, Your Honor.
Now, in these two cases of Montes Claros and GSIS, the the right affected was, in the words of this court, a property right. The right to property in the form of the pension. Now, the Constitution says no person should be deprived of life, liberty, or property. That is why, in this case, the court said a property right was impinged, and they said you cannot do that, due process and equal protection. Okay? Now, my question to you, citizenship, your reading of the due process clause, is that a citizenship, is that a matter of property?
No. It is not a matter of property. And when we evaluate citizenship eligibility or citizenship qualifications under Section 78, our eye, while conscious of due process to the candidate, is to construe the law not so much for the benefit of the candidate, but for the benefit of the state, because citizenship is impressed with great public interest. There is really no right to run for public office, I respectfully submit. It is a privilege in the sense that the Constitution sets out limitations and parameters for the exercise of
Yes,
such a right.
and I, on that score, I cannot agree with you more again, Counsel. But the question I have is, when the underlying question of fact impinges on citizenship, and remember, the due process clause says no person. The Constitution doesn't say no citizen. It says no person. If the underlying question of fact has to do with citizenship, what is involved? Not property. Does it involve life?
No, Your Honor, it involves the privilege of running for public office, which the state can very well regulate.
I hear you loud and clear. I go back to my question. Does it affect life?
Citizenship, Your Honor?
Yes.
Well, in a loose sense,
In a loose sense. Again, that is your interpretation. Because one sense of life is physical life. But in a loose sense, life can be more than just a physical life, right? Now, the second question I have is, underlying issue has to do with citizenship. Does that implicate liberty under the due process clause?
No, Your Honor, because running for public office is a privilege. There is no vested right to public office. The state can very well regulate the conditions and qualifications for which public offices are made available for candidates to aspire for. And the citizenship requirement under the law is not so much for the candidate as it is for the state. It is in the interest of the state to weed out nuisance candidates, to disqualify those who are not qualified, not on the mere say-so of Comelec, but on the very parameters and requirements laid down by the fundamental law, Your Honor.
So you have, and I hear you very clear, you have a very restrictive interpretation of what is implicated in a citizenship issue. You are saying that it is only running for public office. It does not involve life in a sense broader than physical life, or it doesn't involve liberty. I will concede to you it doesn't involve property.
Within the context of this case before the Honorable Court, what is involved is public office. And there is no vested right to it under the law, under the Constitution, and under jurisprudence, Your Honor.
Now, Counsel, I think it just really shows, and again, you have to cover this in your memorandum, that we are poles apart from my interpretation of what is covered by due process, that no person, again I say no person, it doesn't say citizen, no person should be deprived of life, liberty, or property without due process of law. I hear you, but from where I stand, from where I sit, this is the definition of citizenship which in capsule form defines my take on due process of law.
Well,
This is,
Your
I'm not yet, wala pa akong question.
Sorry, Your Honor.
I'm just saying, and then you can disagree in your memorandum, my abiding faith is that citizenship, again, as formulated by former Chief Justice Earl Warren in his dissent, in the case of Perez versus Brownell, as quoted in Bernas, is that, and I quote, citizenship is a man's basic right, for it is nothing less than the right to have rights. So, when you do your memorandum, you now know where I come from. To me, the opportunity of a foundling to prove that he or she has a due process right to life and to liberty, do not take into consideration property, is something that is protected by the due process clause. I hear your interpretation, and again I say, please, in your memo, tell me why I am wrong.
Your Honor, can I comment, Your Honor?
And as you can comment, of course, now, without prejudice to your memo.
Yes, Your Honor. Your Honor, please, with your kind indulgence, this representation will not go far to U.S. decisions on discussions of citizenship. We have that in Texon versus Comelec, where Justice Bitog traced citizenship since the days of Aristotle and enumerated the categories from social citizenship to political citizenship, from civil citizenship to political citizenship to social citizenship, and lastly, internationalization of citizenship, if possible. In all this, I'm mentioning this, Your Honor, simply to highlight the fact that, as pointed out by Justice Bitog in his ponencia in Texon, citizenship is nothing more or nothing less than membership in a body politic, the exercise of rights and duties and responsibilities. It later evolved into political citizenship, becoming the right to be voted for or the right to run for public office. But in always, all of this, the common thread is citizenship, when it comes to public office, is not right. It's not a right, it is not property. It is not even liberty. It does not fall, I believe, under Section 1 of the Bill of Rights. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law, for the simple reason that citizenship is always in favor of the state. Any doubt on citizenship, I respectfully submit, must be resolved in favor of the state, Your Honor.
Thank you, Counsel. Now I go, and in this interpellation, to the only reference I will have, to international law, not on the point of whether there is a disputable presumption that foundlings are natural born. International Covenant on Civil and Political Rights, ICCPR. The Philippines ratified it October 23, 1986, right?
Yes, Your Honor.
So, this is a treaty which binds the Philippines.
The Philippines is bound by the treaty having ratified it, Your Honor.
Convention on the Rights of the Child, or the CRC, ratified by the Philippines August 21, 1990.
Yes, Your Honor, the same thing.
The same. Now, Article 24 of the ICCPR, Section 3, and I quote, every child has the right to acquire a nationality. Article 7, Section 2 of the Convention on the Rights of the Child. I'm sorry, Article 7 of the CRC, Section 1. The child shall be registered immediately after birth and shall have the right to a name, and then I quote, the right to acquire a nationality.
That is correct, Your Honor.
Now, I think we can start by agreeing what it does not mean. I posit to you that the right to acquire a nationality does not mean that a child, this is a foundling, has a right to file a petition for mandamus to compel the Congress of the Philippines to pass a law that will say a foundling is a natural-born citizen. Can you agree with me on that?
Whether a mandamus will lie or not is something that we will leave to the Honorable Court. But I will answer the second half of the question. Within the context of our Constitution, Your Honor, and the Constitution only as the North Star for all these discussions on citizenship, a foundling cannot be considered natural born, not only because what is provided for in those international covenants, ICCPR and UN Convention on the Rights of the Child, is merely the right to acquire a nationality, negating thereby citizenship at birth or from birth. So, Your Honor, please, my answer to the question would be that those conventions do not vest natural-born status on the foundling within the context of the Philippine Constitution, and that is the only document that should guide the proceedings, if I may submit.
Yes, and I agree with you. And for that matter, Counsel, you cannot file a petition for mandamus or whatever petition to ask or to force this court to amend the rules of court to put a disputable presumption that a foundling has a disputable presumption to be natural born based on these provisions. You cannot. And therefore, that is, we can agree, it doesn't give the founding a right to force the Congress of the Philippines. And in fact, the Congress of the Philippines and this court has not come up with presumptions. That's my point, and that's why I have to agonize over the decision of this case. But I posit to you, Counsel, and please cover this in your memo, the right to acquire a nationality means, in the context of due process, that when a foundling goes to any court and it's elevated to this court, they have a right under due process of law and based on these two conventions that the trier of fact and later on this court will have to decide based on the evidence, although it may be summary. And therefore, I say to you, the right to acquire a nationality means, in the context of this litigation, that you had an obligation, I go back, to decide the question of fact of whether all the evidence in the summary proceeding before you induced a belief as to whether petitioner is natural born or based on the possibilities, again, Is it more probable than not that she is an alien, or is it more probable than not that she is natural born? And I am not saying that, and I am saying that that is the meaning of every child has a right to acquire a nationality. Go ahead.
Your Honor, please, the fact alone that we rendered the assailed resolutions denying or canceling the COC after a thorough consideration of all the evidence means that we have answered the query of Your Honor in the negative. While there is a right to acquire a nationality, that is a right that is not self-executing. Not being self-executing, it does not come within the purview of what a natural-born citizen is. Thank you, Your Honor.
Again, just counsel, just to have clarity on what is the divide between us. I am not saying that there is a self-executing right. I am saying, in fact, to you, the Constitution doesn't mention foundlings. Therefore, there is no self-executing right of foundlings. I am even saying, in my analysis, as a sovereign, this court has to decide, and I'm not saying however international law views this. So, please, in your memorandum, I am not claiming that there is a self-executing right. In fact, I am saying, and counsel for Poe have to cover this, I doubt very much, because I cannot find it in the rules of court. In my view, there is even no disputable presumption that a foundling is natural born. The function of this court, and that's why this is such a very difficult case, is that based on your facts, for the first time, and there are no decisions to guide us, we have to make this decision. You know, in the case of the set, at least in my view, they staked a finding of fact. My problem is with the Comelec, you did not stake a finding of fact. In my view, that may be grave abuse of discretion, and you will be forcing this court to make that finding of fact for you.
We will cover that in our memorandum, Your Honor.
I'm still on due process of law. Are you familiar with the Philippine Blooming Males case? Philippine Blooming Males Employees Organization versus Philippine Blooming Mills. It was decided by Justice Macasyar and Bank, no dissent, 1973.
No, Your Honor.
Well, this is one of my favorite cases, counsel, because it is, I think, on page 4 or 5, or it is within the first 4 to 6 pages of the case book of Father Bernas. And the reason it is up there is because it is about the hierarchy of rights. And just very quickly, this court in PBM Blooming Mill said, in a democracy, the preservation and enhancement of the dignity and worth of the human personality is the central core as well as the cardinal article of faith of our Constitution. So please cover this in your memo. It seems to me that the right of a foundling to litigate that he or she is natural born comes within the dignity and worth of a human personality, which is the central core as well as the cardinal faith of our civilization. And that's the Philippine court saying it in 1973. Now, I'll give you another quote, because in these interpellations we have heard so much about the voice of the people and vox populi. The reason I am trying to focus your mind on the Bill of Rights and the first provision of the Bill of Rights, no person shall be deprived of life, liberty, or property, nor denied the equal protection of the laws, is the Bill of Rights is there, and I quote, is there against the assaults of opportunism and the expediency of the passing hour. the erosion of small encroachments, and the scorn and derision of those who have no patience with general principles. Now, and again, I think this quote is very appropriate for this case. Justice Makashar, again, for a full court, no dissent, quoted Justice Robert Jackson of the United States Supreme Court, and the case is West Virginia Board of Education versus Barnett. You remember the Barnett case? This is the flag salute case. And this is the quote: "The purpose of the Bill of Rights is to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles as to be applied by the courts." These fundamental rights protected by the Due Process Clause, and I quote, "may not be submitted to a vote. They depend on no outcome of no elections." Therefore, now you can understand why in this case of first impression, this court should not take into consideration vox populi. We should take into consideration, and I agree with you 100%, the Constitution. Now, you're focusing on your interpretation of your Constitution. I am focusing on the Bill of Rights. Now, the reason I asked you a while ago about whether in the life, liberty, or property formulation, I already offered to you what is at stake here is not a property right. But you are saying it's not even a right to liberty or not a right to life. But this will introduce now the question of equal protection. In this case, again, I'm still saying PBM, the superiority of these rights, meaning the rights to life and liberty over property. That is why I like this case, and I start when I have a course in constitutionality with this case, because this places very clearly where this court is coming from. In the hierarchy of rights, liberty and life trump property. So when you have an issue of equal protection, which is my next topic, it is enough if property rights are involved that you can have the so-called rational relation test. But when you have rights other than property, and I will go into that, this court, way back in PBM, already said a constitutional infringement on human rights requires a more stringent criterion. You remember that in equal protection analysis. So what I'm saying to you, and again, this has nothing to do with American precedents or international law. I say to you, counsel, that it seems to me a person who is a foundling has a due process right and an equal protection of laws right to have the question of fact, again I go back, decided. Now, I will go now, well, you want to react? Or if your reaction is the same, we can cover it in the memo.
We'll just cover it in the memo, except that I would like to add, Your Honor, that Article 3, Bill of Rights, is of course a basic part of the Constitution. And again, I would like to reiterate that there is no vested right to any public office. When we declared the petitioner ineligible vis-a-vis Section 78, there was no deprivation of due process because she was fully heard on that issue, Your Honor.
Now, I go now to equal protection, and I'll try to be very quick so that we can have the interpellation of the other speakers, and we can go to the Solicitor General. Now, in the comment filed by the Office of the Solicitor General, in the set case, it argued that foundlings are and I quote, discrete and insular minority, end of quote. Do you agree to that, or are you willing to stipulate to that?
There are not too many foundlings, according to what I heard in the last hearings, around 4,000, Your Honor, but as to what inferences to draw from that number, I leave it to the court, Your Honor.
So, I believe, if my memory serves me right, it was Attorney Poblador who, on interpellation, I think volunteered the statistic that there are 4,000 foundlings. Now, in view of the hesitancy of Comelec to make a stipulation, may I request counsel for petitioner, in your memorandum, please include the whatever basis, literature, statistics, the SWD, to prove as much as you can that there are thereabouts 4,000 foundlings in the Philippines. And I would welcome the other petitioners or the other respondent in this case to similarly bring to this court's attention what is the statistic, how many foundlings are there. Now, have you read the comment of the OSG in the set case?
No, Your Honor, we are not a party to that case.
The comment of the Solicitor General raises this matter of discrete and insular minority. Now, I have a question to you as a matter of constitutional law. Are you familiar with where the Solicitor General picked up that term, discrete and insular minority?
No, Your Honor.
It is picked up from it is said, the most famous footnote. The most famous footnote, it's footnote number 4 in American constitutional law. It was a footnote by Justice Stone. I think he became Chief Justice Stone. In the case of United States, I think, versus Caroline Products. Caroline, Carolene. Now, discrete and insular minorities, in that famous footnote, is an analysis of equal protection. The position of Justice Stone, or Chief Justice Stone, is that, and I quote, when you analyze a equal protection case, in the United States, they have such a thing as suspect categories, like I think you said gender, race. There is discrimination against women. There is discrimination against blacks. So these are minorities. In that famous footnote, this is what Chief Justice Stone said. I'm not sure if he was Chief Justice at that time. He included what he called discrete and insular minorities as a category of persons who need protection by the court. And the quote is, whether prejudice against discrete and insular minorities may be a special condition which stands seriously to curtail the operation of those political processes ordinarily relied upon to protect minorities. And, this is what he said, and which may call for corresponding more searching judicial scrutiny. In effect, this is a very famous footnote because if a group of persons fall under the category discrete and insular minorities, the court, under this analysis, will subject the classification made by the government to more searching inquiry. In the language that we use in the Philippines, more searching inquiry means strict scrutiny. And we know very well that whenever in an equal protection case, strict scrutiny is the measure, more often than not, the government will lose. Meaning, because in a strict scrutiny measure, the government has to identify a compelling state interest to justify the classification. Now, I'm calling your attention that in the SET case, the OSG was appearing as counsel for the SET because the SET asked them to represent them. And so the official position of the government in the SET case is that foundlings constitute a discrete and insular minority. Therefore, when we decide, it calls for strict scrutiny. And they already said, the government said, in effect, that there is no compelling state interest to give differential treatment between foundlings and other parties. Now, my next question is, and I think in the interest of time, go back to the Montes Claros case and the GSIS case, because in that case, this court, again, in 205 and 204, made an explanation on why, beyond due process, there was an equal protection violation to the rights of the parties there. Very, very briefly, and discover this in your memorandum, in the case of the SSS case and in the GSIS case, they were lumped together. There was a conclusive presumption that their marriages were a sham. It was not fair because the law was making sweeping classifications. Now, I will, and mind you, those two cases were decided just on the rationality case. And in fact, in the GSIS case, read it carefully, the court admitted that the issue of constitutionality was not raised. But motu proprio, the court told the parties to consider constitutionality. And that is in that spirit that I ask the Comelec and all the other parties, please, because from where I sit, there have been violations of due process and equal protection. And I will go to that now as my last point. Using the equal protection clause, I find that the starting point should be to compare the rights of a foundling to the rights of a party, a litigant, whose parentage is known. Because in equal protection, you have to have an apples to apples comparison. Okay. The first objection I have to the method used by the Comelec is, and I think the case of Pa versus Chan, which you have repeatedly cited, is typical or exemplifies the rights of a person whose parentage is known. In the case of Pa, you have a party whose birth certificate said he was Filipino, but that was contested. And therefore, that party had known parents, right? Except that in the decision and based on the evidence, the court found that the parents, while known, were aliens, right?
Chan, Your Honor. Chan.
Yes, Chan.
His father was Chinese.
He's Chinese. Although his birth certificate said, Chan's birth certificate said, his parents, father and mother, biological, were Filipinos, right?
Yes, Your Honor.
And then the evidence, though, showed, and even he had evidence that he had got a public service permit to, I think, run a transportation, or was that an ice plant? In the totality of evidence, the court held that no, the finding of fact was your parents are both aliens, right? So you have, on an apples-to-apples basis, you have a foundling and you have persons like Chan. Okay? A person like Chan, parentage known, foundlings, parentage unknown. I posit to you that the first violation of equal protection is that the Comelec, it seems to me, has already held that en masse all foundlings are not natural born. Whereas in the case of Chan, as you put it, his parentage was known, and yet he was able to prove by evidence, and other than DNA, or the opponent of Chan was able to prove by evidence whether or not he was natural born. So that is my first difficulty. I think the Comelec, by treating them, foundlings, and persons like Chan, violated equal protection.
Can I respond, Your Honor?
Yes.
Counsel, just before you respond, I will be forced to conclude this session in order to allow us to prepare for tomorrow's division sessions, because there are still ponentials we have to release and deliberate on tomorrow. So your answer will please conclude this session, and then we will resume next week. Justice Hardilesa, is that fine at the request of several members?
Yes, Chief,
Okay.
yes.
Thank you, Your Honor. I just wanted to say, Your Honor, that there is reasonable basis for classification, and therefore the equal protection of the law clause is not at all offended, for the reason that the two situations are poles apart. Pa versus Chan is a judicial proceeding where the citizenship of Mr. Chan was an issue as a judicial case to determine whether or not he was eligible to be considered Filipino citizen. in this case before the court now, it is material misrepresentation. It is not so much to look into the matter of qualification, but it is purely to determine whether there has been a material representation that is false, which has been declared in the COC. So we will cover this in our memorandum, but I do concede, Your Honor, that the questions posed by the Honorable Justice are really worth considering. They're a challenge to good analysis. We thank you for those questions, Your Honor.
Thank you, Counsel, and thank you also for all the patience.
We will decide next week whether we will resume interpellating you or we will immediately proceed to interpellating the private respondents and then the Solicitor General. But Justice Hardilesa? Yes.
I thought this will just cut my
would you
interpellation, and I have really just about one point. We can do it
Okay.
the next time. Or
All right. Anyway, because there is quite a demand on me for the divisions to have a little more time. We can proceed with that, and anyway, your last point, we can resume with that next week. Please be advised that the moment that we conclude our session, all the parties are given a non-extendable period of 5 days within which to submit your respective memoranda simultaneously served on all the parties. So this session is hereby adjourned to resume next week at the same time, same venue.
Please remain standing while the Chief Justice and the Associate Justices leave the session hall.